And we are going to call the Joint Interim Judiciary Committee meeting back to order. I understand everybody is here who was here previously before the break, so we don't need to take roll again. We are going to move right along to our next agenda item. We're going to agenda item 4, having already done number 5, and we are going to welcome Victoria Gonzalez, the Executive Director of Nevada's Department of Sentencing Policy. Please go ahead whenever you're ready.
Good afternoon, members of the committee. Again, Victoria Gonzalez of the Nevada Department of Sentencing Policy. I'm the Executive Director. So nice to be here with you today. I'm really looking forward to introducing us in more detail to you, and then looking forward to our partnerships together well, from now on, I hope. So I want to start with a little bit of history of who we are, where we came from, and a little bit of history about the Nevada Sentencing Commission. So the most current iteration of the Nevada Sentencing Commission was actually, I call it resurrected in 2017. It was born out of the ACAJ. What they did in 2017 was they moved anything that was related to sentencing of the ACAJ duties over to the Nevada Sentencing Commission at that time, and also created additional duties regarding advancing policies for the state in terms of analyzing sentencing in different areas, including fiscal analysis, data analysis. Before 2017, there had been I would say back 25, 30 years, different iterations of commissions established to do a data-driven analysis of our criminal justice system. And each version of those either failed for some reason, they never met, they just became dormant, and so they would go away and then come back as a different body. So in 2017, as the ACAJ was evaluating what they wanted to do and prioritize, as we know, ACAJ had many duties underneath its mandate, and so this was a way to take it and focus it on the Sentencing Commission and give them those duties specifically related to sentencing. And again, those duties were, it was important for those to be data-driven. That was the emphasis on the statutory mandates. During the interim, in its first existence, the Sentencing Commission heard from sentencing commissions from other states. And what they learned that was in order to be truly data-driven, they were going to need their own dedicated staff. And so what happened during the 2017-2018 interim was the Sentencing Commission, as it was housed in the legislature as a legislative interim committee, realized it was going to be better for it to be housed independently in the executive branch. So it made that recommendation to the legislature. So in 2019, what they established was the Nevada Department of Sentencing Policy, and they moved the Sentencing Commission to that agency to be housed with dedicated staff to develop data-driven recommendations. Here are the mandates as they exist today and are very similar to how they were established back in 2017. Except for those related to the Department of Sentencing Policy. So you can see here, these duties are specific to the director position of the Department of Sentencing Policy. Generally speaking, the director is required to assist the Sentencing Commission in anything related to its duties and carrying out its mandates. The director is required to oversee the budget and functions of the department and then facilitate the collection of data from all criminal justice agencies, including identifying areas where data is not being collected or shared. The Sentencing Commission, as it existed, as it was created back in 2017, has not changed very much. It is a 24-member commission. We have members from all areas of the criminal justice system. Very generally speaking, the duties of the Sentencing Commission are to advise and make recommendations to the legislature regarding areas of criminal justice system that affect sentences for felonies and gross misdemeanors. They are to evaluate the fiscal impact of sentences, incorporate certain goals and objectives for sentencing, and identify areas of disparity and provide training. I would invite you all to look at those mandates as they are quite extensive and detailed about what the commission should be doing, but this is a very high-level summary of those duties. And then most importantly, because the commission is required to be data-driven and make data-driven recommendations, the commission is tasked with facilitating the creation of a statewide database. That was one of the main reasons it was moved from the legislature to the executive branch, because being housed in the legislature, While the commission benefited from the amazing LCB staff was not equipped to give all of its attention to the Sentencing Commission. So by moving them to the executive branch, they have a dedicated staff to help establish this statewide database. I do want to emphasize, too, that the agency, we are nonpartisan. So being an executive branch agency, and we don't have any sort of specific reforms that we're looking to advance, but we want to make sure we can provide the data and analysis needed for anyone else when they're looking at their reforms. As this committee is very familiar with, AB 236 was the Justice Reinvestment Initiative from 2019, and it was sweeping criminal justice reform to all areas of the criminal justice system. In AB 236, the Sentencing Commission was given tasks related to evaluating and assessing the outcomes resulting from the enactment of AB 236. If you look at the statutory mandate, there are, depending how you count data metrics, either dozens or hundreds of data metrics that need to be collected from the Department of Corrections, Division of Parole and Probation, Central Repository, and any other agency that will help evaluate the impacts of AB 236. The Commission is also tasked with identifying what are called costs avoided from the enactment of AB 236. When AB 236 was enacted, it was promised $640 million would be saved over the 10 years after the enactment of the bill. The Sentencing Commission is required to identify a formula that will measure those costs avoided and keep track of them over time, and then make recommendations on programs, treatment, agencies to invest those costs avoided to reduce recidivism, maintain public safety, and keep the prison population low as AB 236 intended. I will say, too, there are a lot of agencies and stakeholders you can reach out to when it comes to AB 236, and I would invite you to reach out to us. We are definitely experts when it comes to understanding the policies that led to the enactment, how it's going, the current implementation, and any stakeholders you want to talk to that would help you understand more about AB 236. This is an organization chart of how we are organized today. It is not how we were originally set up. Being data-driven and with the extensive mandates that we have a lot of room to grow. So we've already grown a little bit, but this is how we're organized right now. We have a policy analyst. We have two management analysts. We have a management analyst 2 and a management analyst 1. I will highlight that the management analyst 1 duties are split between fiscal activities and budget activities needed to operate our department and the data-driven activities. However, the management analyst 2 duties are totally dedicated to the data collection aggregation activities of our agency. And then we have an administrative assistant 3. One of the things I'm really excited to share with this committee today, in case you haven't heard about it yet, is our dashboard of prison population data that we have created and that we just launched a few months ago. It is comprised of aggregated data from the Nevada Department of Corrections. We update it monthly. So if you go to our website, which is sentencing.nv.gov, and then you go to the hub. And I will mention, too, the hub is where you can get any reports that have come out of our agency, the Sentencing Commission, any other resources we have. Anytime you're looking for anything that we can either direct you to or reports we put together, go to the hub and you'll find what you need. And keep an eye on this as it'll continually grow as we add more information. So you can see here is our data dashboard. So you click on NDOC Trends. And there are 7 different dashboards that you can navigate. So here we just have the general population trends. You can see that we go back to 1990. You can manipulate this data however you like. You could sort it by year. You could sort it by population. And you see we have it divided up by, you can either see the total or you could look at divided by male and female. The next dashboard compares the population to the Jfa projections. As many of you may know or not know, what drives the development of DOC's budget, the Division of Parole and Probation's budget, and the Parole Board budget are the projections put together by JFA. And so they put these together 3 reports every interim. And what we've done is, in order to understand how the projections change over time in relation to the population, you can access here. On the next dashboard, we divided up by admissions and releases. Again, you can see the trends over time and the comparison of those. And then we do have some pie charts available based on admission status. You can see here that you can manipulate the data to go by county, to go by admission status, and then going back, we have back to 2017 for this data. And then here we have admissions per year based on admission status as well. So, for example, one of the pieces of data that was analyzed that led to the enactment of AB 236 was wondering about those individuals who are coming back from supervision. So a parole violator, a probation violator. A lot of the reforms in AB 236 were targeted at trying to address the admission status of those. So if you wanted to see the trends in those areas, again, you can manipulate the dashboard to click on those areas of data that you are looking to understand more the trends. We have release by status, again by county, and again by status. And then the releases per year is similar. So one of the things we're really excited about with this is this has never been done before. It's been really hard to get data, have it all in one place. And what we're learning, as we know already the challenges with data, is that I think one of the roles that the commission can play, that our department can play, is being your centralized area for criminal justice data. As we know in this state, we don't have anything that's uniform. I know the discussion of uniform courses come up, but nothing is uniform. Nothing is on the same system. And so while the commission is tasked with building a database, I think in reality what that database is going to look like is going to be our hub, where we have data from different areas that has been aggregated and collected and presented in this way. And then all of our stakeholders, the lawmakers, the public, have one place to go to access data, rather than having to make individual requests that may result in inconsistent results depending on when the request is done, depending on those that do the analysis. And so I show this to you to, again, show you our vision for where I know we are going to end up and how we are truly going to be able to develop data-driven recommendations for this state when it comes to any sort of reform or change that our lawmakers and stakeholders are looking to do. The next thing I want to mention is something that's called Justice Counts. We just discovered this last week, and we're very excited about this initiative that is taking place, that was announced by the Department of Justice, Justice's Office of Justice Programs, Bureau of Justice Assistance, and this is being led by the Council of State Governments. So what they're doing is they want to help criminal justice policymakers across the country make better decisions with data that's accurate, accessible, and actionable. The initiative will aid criminal justice policymakers and agencies across the country to make data-driven decisions using more accurate, timely, and cohesive information. We're often forced to make critical decisions about criminal justice policy and public safety using limited or stale criminal justice data. The project will collect local and state-level criminal justice data within defined metrics and display the information on a web-based dashboard accessible to all. Technical assistance will be provided for states that adopt Justice Counts as an approach to creating a culture of data-driven criminal justice policymaking. The project's Tier 1 metrics cover 6 categories. So we've included those Tier 1 metrics with your materials, and we've included the info sheet about Justice Counts with your materials. So you can see those 6 categories are capacity and costs, population movements, operations and dynamics, public safety, equity, and fairness for each of the following 7 sectors of criminal justice: law enforcement, prosecution, defense, courts and pretrial, jails, prisons, and supervision. Justice Counts is offering 2 opportunities to become involved. 10 states can be part of the founding state program, and 15 states may apply to the implementation grant program. Interested states must take steps to participate and become Justice Count states. To start, the technical assistance must be requested. The next step would be to conduct an assessment of current data infrastructure. The project requires a designated assessment be taken by each of the state's identified criminal justice agencies. Much of the data needed to fulfill the metrics request probably already exist. The difficulties come with extraction, aggregation, and sharing of that data, and this tracks with what we have found regarding our own Nevada data. This exciting prospect comes at an opportune time in our criminal justice data request. The technical and monetary support opportunities available to chosen states could comprehensively assist Nevada in reaching the data goals we've already identified and initiated. With current funding, staffing, and data access challenges, participation in justice counts would give Nevada access to expert assistance to grow our data capabilities and exponentially allow for data-driven, data-informed policies we all work toward to support our criminal justice system. So our next steps are going to be to submit that letter requesting technical assistance. I see the Nevada Sentencing Commission as being the leader of this since we are already on track to house this data. And so we are shooting to have that letter submitted by the middle of June and anticipate being one of the leading states in submitting our request. By having the Sentencing Commission already established, we already have this public body that's ready for this data to do the analysis and support this effort. And then we're also going to work with our stakeholders who will come from our membership of our commission to complete those assessments that will give us that measurement of where we are today. What I have for the committee today, if the legislature is interested in also supporting this effort, would be to put forth a resolution that adopts Nevada as a justice counts state. But we look forward to updating you on the status of that technical assistant request and anticipate being able to be very active in that effort. So with that, I'd be happy to answer any questions the committee may have.
Thank you. Any questions up here?
Just one.
Go ahead, Assemblymember O'Neill.
Thank you, Chair. Just one quick question. What is the budget?
Our budget is just under $600,000 per year, so it's just about $1 million.
It's about $1 million, and it's all general fund?
It is all general fund, and over 90% of that is the staffing that you see for the 5 individuals that we have, and our operating costs are limited due to that. But yeah, 90% of it's staffing, and then it's just under $600 a year.
Thank you.
Thank you. Do we have questions from the members of the committee online? All right, go ahead, Senator Harris.
Thank you, Madam Chair. Let me go ahead and turn my camera back on. Sorry about that. I'm excited to hear about all the data collection that you're doing. Last session, we passed 2 bills that require some additional data collection, one related to traffic stops and the other related to use of force. However, the Department of Public Safety is in charge of collecting that data. I was wondering if you think there's any opportunity to bring those efforts together under you, or if there's opportunities to collaborate in other ways to make sure that our data is unified and, maybe part of this hub.
For the record, Victoria Gonzalez, yes, I think there's absolutely an opportunity for that. One of the, we just had our most recent Sentencing Commission meeting on Monday, and one of the things that I mentioned to the commission that I think we need to start looking at is revising our statutory mandates. They are specific to looking at the criminal justice system as they relate to felonies and gross misdemeanors and felonies. But in reality, what we're doing is much bigger than that. We're looking at the criminal justice system, and I think that what you're mentioning is something we could start looking into right now, and then by broadening our mandate, we just look at everything with criminal justice and centralize this data. And because of our partnerships right now with the Department of Public Safety, we would already be on a track to start trying to figure that out. And so that's what I would recommend is we start looking at just broadening our mandates and scaling them back, and then we could just take on more and more of those duties and be able to house that in our agency.
Thank you.
All right, other questions from members online? Okay, both shaking heads no, so we will go down to our members in Las Vegas. Any questions down there?
We do. Assemblywoman Summers Armstrong has one.
Please go ahead.
Thank you, Madam Chair. Thank you so much, Ms. Gonzalez, for the presentation. Question about what you're using to collect this data. Is this an in-house system? Do you have the funding for expansion of the system, for additional servers because the data is going to grow exponentially, especially if you want to take on more responsibility. So those are two. And the one that I'm concerned about, you said that the data comes from the Department of Public Safety. I'm going to guess that's a state agency. Is that correct? Okay. So they're collecting from our local law enforcement. Is that correct?
So to clarify, Victoria Gonzalez for the record, to clarify, so the data, the dashboard we have right now comes from the Department of Corrections. If we were to collect the data that Senator Harris was talking about, that would come from the Department of Public Safety. We do collect some data from the Division of Parole and Probation. The data related to traffic stops would be a different kind of data. So I want to pause there to make sure that we're on the same page with the data we're talking about. But DPS is a state agency, DOC is a state agency, so I'm going to go back to you to make sure I'm on track with your question.
Okay, so thank you, Chandra Summers Armstrong, for the record. So the dashboard is Department of Corrections. What Senator Harris is suggesting would have to come from DPS?
Correct. So Victoria Gonzalez for the record, our statutory mandate requires us to collect from P&P, from Department of Corrections, from the courts. We are statutorily required to collect from every single criminal justice agency in the state. And so we are just going to take one bit of collection of data at a time will be our goal. But yes, the data that Senator Harris is talking about was because she mentioned going to DPS, that would be a place to start. Because I am learning much about how our data systems work, I think that would actually also take going to the local jurisdictions to go get additional data, especially if we're talking about traffic stops and use of force. But did I answer your question on that part?
Yes, I think so. If I'm going to just repeat to you, this is Chandra Summers Armstrong, to make sure that I understand. In order for us to expand, at this point, you're not there. You are incremental steps. Right now, Department of Corrections, and then as you grow, you'll be able to gather data and drill down into some of our local stuff.
Correct. So Victoria Gonzalez, for the record, if I could expand even a little bit more and go back to the first part of your question about the funding. So I don't know how familiar everybody is with, I guess, how much it costs, but $600,000 a year is not very much. I'm very grateful for it. So don't get me wrong, and you can see how much we're able to do. However, to truly develop the data that we're trying to do, we are going to need to grow. I don't know what that looks like right now, because right now what we're doing, to answer the other part of your question about how the data is being collected, it's being collected in whatever form we can get it in. So, but we make sure to clarify what that data looks like. So we actually have so much raw data from parole and probation that we can't do anything yet with, but we will be able to when we get our staff up to where I need them to be, which is we're close to be able to start looking at that. But the way the data was submitted to us is in a form that's going to take a lot of cleaning, and so we have that data. Some of the data you see on the dashboard has already been aggregated by the Department of Corrections. So we look at that data. However, we would prefer to have raw data because that allows us to then clean it and then house it in a way that can be consistent rather than individuals making their own separate raw data requests. It's better for one entity to centralize it and then clean it, and then we have one place to get it. But I'm not quite sure yet what our IT infrastructure needs to look like. One of the challenges is when we start bringing on individual servers and databases is we need to figure out how we're going to maintain it. And so that's where I'm trying to figure out where we go next is do we focus on just building up our staff to be able to collect, clean, and aggregate raw data? And then do we try and figure out how to house it in a server? Where my focus has been staffing. Because at least with that, I know we can get in there, we can look at the data, we can clean it, we can aggregate, we know what it's doing. But at some point, we will need an IT infrastructure to create that. What comes with that is maintaining it. So then we also would need to figure out how to work with EATS on that, the state IT system or department, to figure out how do we maintain it. And that's a bigger project, which I'd be happy to come back and talk more about that. Each agency that has to collect data faces different challenges. DOC has the way that they house their data, they have their own IT. P&P, parole and probation, they use EATS. So as we get further with that, I have to figure out what does that look like. So I figure at a minimum, if we can get staffing and I can get the raw data, we can get it for you. So that's where I'm starting first, but I'm very aware of the additional infrastructure we're going to need. But we're off to a good start. And I will say I've got a great team that we can come to you and give you all the information you need to understand it. And I'm learning how all these systems work. And I think the way to bring them together is through in this way. Have us start collecting it. And I think if we can do raw, the better, raw data, the better, because then we can then have a consistent methodology with how we're aggregating it and presenting it.
Thank you. I think I have a question as well. You had mentioned something, I don't know if you were here when there was the presentation from the Fines and Fees Justice Center. It sounds like I see you nodding your head. They had mentioned something about how they would request that your agency actually collect that information. And I know I have the frustration, which I'm sure everyone on this committee does, that it's often difficult for us to make informed decisions because we don't have any of that data collection to be able to make those informed, like evidence-based decisions. You had mentioned just briefly there that under our current statutory structure, you don't have the ability to examine sentencing structures for misdemeanors. Is that correct?
That's correct. Specifically, the commission is tasked with looking at gross misdemeanors and felonies. We are looking at other areas, and so I think you could make that argument, but I think to be safe, we'd want to make it clear in our statute that that is part of the mandates to do misdemeanors as well.
Okay. And so in addition to that potential like statutory clarification to allow you to a sentencing commission and a sentencing policy commission, it's so funny that you have to actually say that out loud to study sentences. We would have to make that change. The other thing I have is, I know that you guys do an amazing amount of work. In order to look at some of that data and analyze the data that raw data that we have, how many people do you anticipate that you would need to how many data analysts would you need to do that?
For the record, Victoria Gonzalez. Right now, I would anticipate one additional analyst because I have one dedicated analyst and then half of an analyst. I think another one because of the support we could get from Justice Counts. And so if we get that technical assistance from Justice Counts, there's a lot of the gaps they could fill in for us, and then they'd be able to teach our staff, and then we would be able to maintain it. And so that's going to be my long-term concern is having that staff to help maintain it. And so I think if Justice Counts that technical assistance can get us off the ground, then I foresee, if this were to come forth, I would put forth a fiscal note for one person.
And then my follow-up question is, in addition to any potential matching funds or grants, is there any changes to statute that we would have to make in order to make it so the Department of Sentencing Policy would be able to apply for grants and matching funds? Or do you have that ability to do that now?
We currently have the authority through the chair of the commission. I would need to look into if it would help to do anything additional to the department itself, but we do have the authority through the chair of the commission to apply for grants on behalf of the Sentencing Commission.
Thank you. That's all I have. Do you have anything, Elaine? And we don't have any other questions down south.
All right, then I think that brings us to our conclusion, unless I missed anybody. Thank you so much. It sounds like we have some follow-up to do with you offline as well, but we appreciate your presentation. That takes us to the next phase of our meeting. This meeting has two major components. The first one we have now completed, which was bail and sentencing and fines and fees. The next portion of our meeting is going to be dedicated to summary evictions and evictions generally. I have been so lucky to have the help of Assemblymember Summers Armstrong with coordinating all of these presenters and getting ready for all of these discussions that I am going to hand the figurative gavel over to her to invite up our next presenters and walk us through or guide us through agenda items 6 and 7. So at this point, here's the gavel. And it is all yours, Assemblymember Summers Armstrong.
Thank you, Chair Scheibel, and for the members of the committee for, well, giving me my first chance. So, again, my name is Assemblywoman Chandra Summers Armstrong, Assembly District 6, and we are going to start our phase of summary evictions with our first speaker, who is Judge Zaragoza, who is here in the audience down in Southern California. Oh, Southern California. Did I say that? Wow. Southern Nevada. Thank you, Judge.
Good afternoon, and thank you for having me. I think I need to get my presentation up here. All right, so is that up? Can you, okay. So I was invited to speak about eviction diversion programs and specifically what the Las Vegas Justice Court is working on. So I just wanted to kind of start with a little bit of history with everything that happened during the pandemic and ever-changing federal guidelines, whether it was coming from CDC or CARES Act or local governor's directives, legislation. The last couple of years were very challenging for the courts and all of our customers, litigants, and the like to kind of stay on top of everything that was happening. So about, I would say, a year and a half ago, we informally formed a group of stakeholders that were beginning the discussions of how we were going to move through the system, what kinds of changes would need to take place. That led to the Supreme Court initiating a mediation program through Home Means Nevada that further after that led to, based upon Assembly Bill 486, which was with respect to staying eviction cases for rental assistance applications, that led to further discussions about kind of how to manage that because the court and the counties, social services, which really was dealing with all of those rental assistance applications, didn't have a mechanism of communicating with one another for a large volume of cases. I mean, sure, you could pick up the phone and we communicate, but in terms of figuring out the status of any one rental application at any given time, when we had thousands kind of at any stage, and that was a changing factor, we had to figure out how to deal with that. So this first slide just kind of demonstrates really a group of all of the stakeholders that were together in discussions and have been in discussions for almost a year and a half now about addressing preventable summary evictions, preventable evictions overall. So just to kind of give you a landscape, I know some of this information is not new to you, but looking at our county, Clark County's population, and then the township population for Las Vegas Justice Court, plus the median income and just we know that case filings are increasing, and I have a couple of slides that will talk about some reasons for that, and then rental assistance funds are being exhausted. So where do we go from here? This kind of shows you, this next slide, a picture of, on average, you can look back at these last 5 fiscal years and see the Las Vegas Justice Court really handles almost 75% of the entire state's summary evictions. That statistics held true even when numbers dropped in fiscal year 20 and 21. So the blue there is just Las Vegas and the brown is the entire rest of the state, which you can see. Now, obviously the three top jurisdictions that fall behind us are Washoe County and Reno Justice Court, Henderson Justice Court, and North Las Vegas Justice Court. This slide here shows you a little bit of what we've seen in fiscal year 22. The top red line is the total number of eviction filings. I take that, there's a misnomer on this slide. It's not in Nevada, this is Las Vegas Justice Court. So I apologize for that error. But traditionally, we see about 2,500 new evictions a month. And so you can see the total numbers are shooting up well over 3,000 for most of the months of fiscal year 22 and jumping up in the last few months up to 3,600 and 3,800. The brown line there shows you the portion of those cases that are strictly non-payment of rent. The orange line at the bottom are the others, and you can see those numbers are fairly small in comparison to the totals that we're getting. Those are anything. We don't separate them by the exact type. We don't have that specific data point, but we do separate them by non-payment of rent versus anything else. So the anything else could be nuisance, it could be a violation of a lease provision, it could be no cause. So that comprises all of the orange line. But one of the really interesting things about the slide is the green line. And we've seen a huge increase in the number of cases in which we're going to talk a lot today in my presentation, and I know Mr. Birchtold will speak in his as well about this construct we have in Nevada where the tenant files first. So we're going to talk a little bit, but this green line are those cases where the tenant did file first, but then there was no complaint filed. So by court rule, those cases get dismissed and sealed after 45 days, which is why the March and April numbers are so low. The time just hasn't passed yet. So the 45 days hasn't hit, so they haven't been dismissed yet. So they're not such a significant drop off. As we get further down the road, those numbers will jump up once we do the dismissals and sealing of those cases. But that's a significant number, and that's one of the areas that this kind of informal group has addressed, and that is tenant engagement and tenant participation in the process. So I'm going to shift and kind of just focus on the non-payment of rent cases because those are the bulk of what we see and really the focus of our discussions. Our existing system, as you know, starts with day one where a landlord serves a 7-day pay or quit notice. It's a 7 judicial days. But here it's that 7-day window that used to be about 25% of tenants even bothered to respond with the courts. We've increased that number over the last 18 months to 50%, which is a pretty significant jump up. We still have a lot of work to go. We know that we just don't have a lot of tenant engagement. There are many reasons for that. I know Mr. Birchall will probably talk about some of that as well, but some of the reasons that the court sees are they're just confused. They are confused by the mixed messages that are being sent from media sources about all the different changes out there in law and believing that they don't have to respond. Oh, there's a moratorium, I don't have to respond. Well, there's confusion about that. There's also confusion just on the forms we use. And over the years, legislation has passed over many, many years, probably 20 years worth of time, where there's always adding more information to the notice because you want your tenant to be informed. But it's gotten to the point where we're tipping the scale the other direction. There's so much information in the notice, it's overwhelming. It's so confusing for a tenant to look at. And we hear that a lot in court, is they just don't understand. There's too much information and they can't digest it and work with that. There are some other reasons too, and I won't steal Jim's presentation on that issue. I know we've talked about. But at this point, there's no court involvement. This all happens outside of the court. One of the things that is frustrating, and I know Assemblywoman Summers Armstrong, you asked specifically for some data. And one of the pieces of data that we do not have in the state of Nevada is how many eviction notices are served. We have no idea. They're not filed with the court. Our current statutory scheme does not require the landlord to present those to the court, so we don't know. We only know the cases that ultimately either a tenant responds to that notice to contest it, or when the landlord comes in and files a complaint if the tenant did not respond. So we don't know the number of notices that go out that lead to a tenant to satisfy whatever the notice requirement is. We don't know how many notices go out that the tenant just leaves because they don't contest it. So we don't have that information. And I think overall our discussions with this larger group have been we should know that information. That data is important for social services, for rehousing, to know what's coming, to be prepared, and we just don't have that under our current system. In our current system, you have that day 8 reaching out over to about day 20 or plus, where the court has engaged in this very rudimentary process because we don't have any technological interface between Clark County Social Services and the court system. So it's really a matter of drafting a spreadsheet, sending it over by email, having someone at Social Services update us with all the information about whether rental assistance applications have been approved, disapproved, still pending. We do that in that rudimentary fashion. And of course, with that changing daily, we send a new list daily to Social Services. So if the case was pending on Monday, that case is going to still end up on the Tuesday list. And we're going to send it over and they're going to do that search again. And if it's still pending, it'll end up on the Wednesday list. We don't have a good mechanism of getting that data back and forth. And that has, with respect made AB 486, really frustrating for the court to kind of keep our arms around it and not just know how we're supposed to respond to the case, because we have to take certain action based upon the action of Social Services. And if we don't know what they did, we can't close our cases. So it's a little, it's tedious, I guess. So what we do is we send a list over of every case that we have. That alerts Social Services that, hey, we know that we have this case here. They then contract with a nonprofit organization. They have 3 different organizations they contract with to reach out, to make that outreach to a tenant to say, hey, you haven't filed a rental assistance application. Do you need to? We can help. So there's that process that's working. So far, the court has made to Social Services 19,002 notifications. I think that number was good as of April 21st, so not as of today. And of those, 4,024 ultimately ended in approved rental assistance application, which is about 22%. This chart here kind of shows you the breakdown of those 19,002 cases. This is not by any means all rental assistance applications that CHAP gets. This is just the 19,002 cases that the court refers, if you will, to Social Services. You'll see, surprisingly, as we've talked about tenant engagement, the extraordinarily large number of cases where they reach out to tenants and they can't even reach them. That's a really large number. There's also, large number where the tenant doesn't want any assistance or the tenant's already moved out. There are a number of issues here. But another large number that I think is significant for us to consider is this duplicate. So you can see just the, inefficient system that we have in communicating with Clark County. We notify them at the first chance we get, but the only mechanism we have is when the tenant files an answer. Now we know who the tenant is, how to reach them. We know there's a case, so we notify Social Services. If there's a motion to stay or a motion to set aside or something like that that's filed after the eviction has already gone through the system and been granted, we notify them again, and that's what ultimately ends up in this kind of a weird duplicate notification. So that said, if you subtracted out those duplicate notifications to Clark County, then this 4,204 approvals would increase that 22% significantly. So in the eviction diversion world, what we've looked at is kind of developing some goals. What are our goals for diversion? What does that look like? And how will that help us to identify preventable evictions? The first goal that we have identified is to develop strategies that would remove whatever barriers there are to tenant engagement. We know the notification form probably needs some simplification. Some of that may end up requiring some legislative change. And it's not that we don't want to not tell tenants something, but we might want to focus on the most important pieces and how we get those tenants to respond so that they're at least engaged in the process. We don't want to give them what we would call like the fire hose effect of too much information and then they do nothing. And that's kind of where we feel like we are right now. We also think that one of the other barriers to tenants is they don't think it's real. They look at a notice because it doesn't come through the court. It comes directly from their landlord. Some tenants just don't believe that it's real. They don't believe that it's a legal process because there's no file stamp on it. It doesn't come from the court. So we've talked about strategies to kind of change that procedure, whether that's through court rule or subsequent legislation, but to make those notices come through the court, give them some official make it official. It comes from the court. Now they know that it's real. They need to act. And then this third part is really kind of moving into that diversion process, and that is to create a system for that warm handoff of a tenant to resources. Because identifying resources on a landlord's notice form that's going to a tenant who's now scared, overwhelmed, whatever they're feeling at that time. Sometimes a tenant's not in the right frame of mind to be able to reach out for those resources themselves, and we need something that's a better system to hand them off to resources. So back to kind of looking at our existing system and some of the things that we've been looking at that either work or don't work, and how we can incorporate some changes into a true robust diversion program, are this mediation program. So the state Supreme Court initiated the mediation program, and then you kind of had layered on top of that the mediation that was put forth in Assembly Bill 486. So those cases are all referred to Home Means Nevada. Home Means Nevada contracts out with attorneys who act as mediators on those cases. And that happens between, when the notice period expires and now up to a 45-day period, because it takes some time to I know the statute says 30 days, but that always can't be done in 30 days. Sometimes it takes longer. One of the things that we've discovered through just discussions with Home Means Nevada and Shannon Chambers, who's the president of that organization, is a lot of mediation is simply just dependent on rental assistance. So if it takes 6 weeks to process a rental assistance application and our mediation efforts are supposed to be done within 30 days, we're kind of missing the window. It's almost like the CHAP application process has to work itself through before a mediator can effectively mediate a case. Because a lot of non-payment of rent cases honestly don't move to mediation and aren't successful in mediation unless there is money to satisfy the default in rent. And we're talking, many of these tenants are provided thousands of dollars. It's not just 1 month's rent. Most of them are being provided many, many months of rent to cover those defaulted periods of time. One of the issues that we also found is that when we ask our mediators to try to be creative or think outside the box in terms of mediation to avoid an eviction, they do. They might come up with something that is a move-out date, or maybe moving them to a lower, less expensive unit or something like that. And when those don't get followed through, if there's still a rental assistance application pending, even though they've kind of worked out a resolution or maybe they've worked out a payment plan, the courts we can't enforce those agreements. So we've put our mediators in that position where they're trying to be creative in their mediation, but if something goes awry in that mediation and there's no follow through, the court can't enforce those agreements while there's still a rental assistance application pending. So again, we kind of want to move the rental assistance application to the front of that process. Again, the other part about mediation is it doesn't discuss really rehousing efforts, because they're not case managers. They're not, they're not providing family services. They're lawyers who are trying to mediate a case as they would in a civil settlement conference. And there's no connection of that tenant to resources. So the mediation alone, while it has a benefit in many areas, it doesn't cover all of the needs. We've been told that rental assistance funds may be extended through October of 2022. I don't think that's by any means a hard date. It all depends upon the cases that are coming through, the number of months, the eligibility, and those things. But that might be not the end of rental assistance forever, but the end of the large buckets of money that the federal government has provided for this really robust rental assistance program that we have now. So we need to think in the future and be proactive in what does it look like after that money, the big pot of money is gone? What does that look like on a sustainable basis? And so that's one of the focuses that this group has endeavored to discuss as well. So this little graphic here, I kind of, to show, while rental assistance is doing a great deal of good in satisfying defaulted rent, and you can see this first little hazard symbol here, it's avoiding that first eviction, but it's not avoiding the second or the third or the fourth. So what we've seen, and the other reason I believe that there is a large increase in the number of eviction cases we see, is because we're seeing the same cases over and over again. Let me explain what I mean by that. The first pot of money that came to the county for rental assistance had certain federal restrictions on it. They were only able to provide up to 12 months of rental coverage for any individual. So if somebody exhausted their 12 months, that tenant exhausted their 12 months, they were, the landlord was cut a check. But then you have month 13 and month 14. And if the tenant isn't connected with resources to change their scenario, then by rental assistance, it's helping them with the past, but it's not helping them in the future. It is then after month 13 and month 14 now go unpaid because there's not a change in circumstances, that there's a second eviction filing. That second eviction leads the tenant to apply for rental assistance again. Now you get to ERA pot 1 of money, which allowed them to spend up to 15 months. So they get 3 more months of rental assistance, which is great. It covers them in the past for months 13, 14, and 15. By the time that case gets through the system, they've now been provided 3 more months of rent. Again, they're not connected to resources. There's no change for their future at that point. And now you have month 16. So the landlord files another notice of eviction because they haven't been paid for rent for month 16. They go back to rental assistance again. Now ERA pot 3 of money, or pot 2 of money from ERA, covers up to 18 months. Once that 18 months is gone, now what does the tenant do? How do we prevent that eviction? So in an 18-month period of time, sometimes less if the rent was due as far back as March of 2020, sometimes tenants are getting rental assistance for, let's say, June of 2020 to May of 2021 for their year, or maybe even their 6 months after that. And we're here in May of 2022, and they've already exhausted their 18 months. So it's not necessarily what we've been doing is just kind of detouring the eviction, and we just keep on coming back to it over and over and over again. So we see the same landlord and tenant, sometimes 3 and 4 cases, and nothing's ever really resolved for either party. So that's the idea of diversion, is we want to divert out of this endless loop of coming back to the same eviction and trying to prevent future evictions, not just the one that's at hand. So our goal number 2 is to develop a triage component to potential eviction cases to identify those preventable evictions. Our strategies are to kind of identify all community resources. We've done a lot of that already. Bring those resources to our eviction diversion program. And then I'm going to explain what our strategy number 2 here is, and that is to use a care team approach to identifying the needs of the individual tenant and connecting them or providing them resources. In the next couple of slides, we'll talk about kind of what the care team approach looks like. And this is really kind of encircling the tenant with various pieces. So we've got family service specialists, eligibility workers, mediation will now be brought in. Instead of the court sending out, we'll have Home Means Nevada bring mediators in to our eviction diversion program so that everybody's there at one point, helping with financial counseling, helping with legal assistance. And that's really our partnership with Legal Aid of Southern Nevada and their role in this entire diversion process, so that we can help them with things like not just rental assistance, but rehousing when necessary, financial counseling, mediation, vocational training, job placement, those things that can put them back into a stable environment. And this is our CARES team approach that we have identified in terms of the 14 positions. So we're looking at 2 program facilitators who would be family services supervisors They would be housed within the court, but they will have kind of a dual role of being housed in the court for this program, but having access to Clark County Social Services software and their case management system. They will have case managers. Then we have 2 senior family services specialists who are the case managers on each team, a legal office specialist, which would come from the court. The senior family services specialist will actually be housed with social services, and that will, how do I say that? They will work for social services, but they will be assigned to the diversion program. So they'll work in the court physically, but still be a social services employee. And that's kind of how we've talked about bridging that gap between county social services information and the court's information. And then the eligibility workers would work with the court. So our hope is that somehow we're at the beginning stages of kind of working out the process of that with this larger group. And we've already had kind of one large retreat day, if you will, planning, and some discussions about how we would make that work through either proposing legislative changes or perhaps court rules that would change that in the interim. But the idea would be that we would direct tenants to come to the court through a notice that would come through the court system. We would then give them an order to come to the eviction diversion program. And that would happen within the window of time that they are supposed to respond to this eviction notice. That would put them in connection at that front stage with somebody evaluating their situation for eligibility, evaluating the case for mediation, potentially mediating the case, having a connection with a legal representative right there who would explain to them more of the details of what their options are, whether they should contest it, how they contest it, helping them contest it, if they need to file an application for rental assistance, helping through that. And we want to add to this, each of our teams, we would add on there as kind of, they wouldn't work for the court, but they would be part of the team, a legal aid representative who would be there, or a legal representative, wherever that would fit in, a financial counseling specialist, individuals from nonprofit organizations that have resources that might be of assistance, vocational training, things like that. So that's kind of our structure that we have come up with. This CARES team model is something that the county's had in place for a while now, and they use it in other programs. One specific program they use it for is for individuals being released from the Clark County Detention Center. And so they use this same CARES team approach to address the needs of that individual in that transition from the jail back into the community. And because they've had success with that, it's this construct that the county recommended and proposed for us to use for this process as well. One of the other issues that we have, and this is part of not having that tenant engagement up front, is we have
I'm so sorry,
in our
Judge-
existing system.
Judge Saragosa.
Oh, yes.
Assemblymember Summers Armstrong is in charge, but I was just informed that we are having a technical problem with the live stream.
Oh.
So I want to make sure that we get that fixed so that anybody who's following along at home catches all of this important information. So I guess we'll go into a brief recess and address the technical questions. I'll be right back. All right, my sources tell me that the live stream is up and running.
Thank you, Chair Scheibel, for giving us an update. Judge, if you might want to just go back a little bit in your presentation, maybe to the CARES team once again, in case that was missed during the live stream interruption, and then move forward from there.
Yes, thank you.
Thank you.
Judge Melissa Saragos again, and I just realized I probably didn't even introduce myself at the beginning, did I? That's terrible of me. I'm Judge Melissa Saragos. I'm the Chief Judge of the Las Vegas Justice Court, and I've lost my mind this morning, or this afternoon, I guess. So back to part of the discussion about what a CARES team is and kind of this concept. So the county uses this model that they refer to as a CARES team in several other areas. One in particular they use with the transition of individuals who are being released from the Clark County Detention Center back into the community. And so they use this kind of an approach to provide them a case manager and resources and eligibility and things like that. So when we started talking about this, because Clark County is obviously one of our major partners in this endeavor, they suggested that we adopt that same model because it's been successful in that area. And so that's kind of where this construct came from. And the idea is that we would have family services supervisors who would act as our program facilitators for the eviction diversion program. We would have senior family services specialists on each team that would act as case managers. That is their function. And although those two individuals would be employed by Clark County Social Services, they would have as their assignment the eviction diversion program through the court. So they would be physically located with that program in the court. The eligibility workers and legal office specialists would also be part of that team. So these are the 14 positions that would be funded for the actual court employees / social services employees. But what we want to have added in there is representatives from Home Means Nevada for mediation, potentially representatives from the Neighborhood Justice Center, which is also a mediation resource, representatives from either legal aid or legal services that would be able to be there and provide legal information, legal assistance, and legal representation to a certain degree of our tenants who are coming through the system. We would also want to add on there some nonprofit organization representatives because they have connection to resources as well, and financial counseling specialists, things like that. So that's kind of our idea, is to build up. This is our core little basic shell of a team, but we would add to those teams to make them very robust so that when our tenants come through, they would kind of be surrounded by this. Now, that said, that's going to take some procedural changes. So our idea is that the tenant would be given a notice, say a non-payment of rent notice, eviction notice, that would come through the court, be official. And once that notice, that the landlord presented that notice to the court for issuance, the court would also then maybe issue some type of order that directed the tenant to come to this eviction diversion program for assistance. That being said, then legal aid would have access to that information. They would also be able to potentially reach out to tenants. So our hope is that we can increase that tenant engagement again. And if we can increase the tenant engagement on that front end and provide them all of these resources within that time to respond, whatever that time is, right now it's that 7-day period, then we would be able to act quickly so that it's not months down the road and they owe even more months of rent, which is harder to dig themselves out of than right at the beginning stages. We would be able to provide, or prevent, I should say, additional evictions that are indeed preventable. So again, kind of giving a glimpse of our existing system and one of the court's significant challenges, and quite frankly, a significant challenge for tenants as well. If a tenant is presented with an eviction notice and they don't respond to it for whatever reason, whether it's just confusing or, they don't think it's official or whatever the reason is, and that case comes through the system, it is not an automatic grant of a summary eviction by any means. I know some people believe that, but our court does an entire legal review of every eviction, even when the tenant does not respond or contest the notice. We still review every case for legal sufficiency. We have a singular paralegal who reviews every one of those cases and then makes those recommendations to the hearing master, who ultimately rules on them. And there's a fair percentage. I mean, it's not a large percentage by any means, but a fair percentage that are denied outright, even if the tenant did not engage in the process. But when the majority of those that are the landlords that go through that system and file a complaint and they are uncontested, when they meet legal sufficiency, they are granted and an eviction order is issued. When that order is issued, we refer that, or we send it over to the constable's office. Other jurisdictions would use the sheriff, of course, but for Las Vegas Justice Court, we use the constable, and the constable will post that order to the door of the tenant and note on that order when they are going to come back or return to do the lockout. That's generally 24 to 36 hours later. I will say sometimes it goes beyond that because of their resources. That window of time, that 24 to 36 hours, is a frenzy right now. And not in a good way. The tenant is panicking. They've got this order on their door. Sometimes they may not even have received the notice, or maybe it got lost, or they didn't pay attention to it, or somebody took it and didn't think it was serious, whatever the circumstances. They're now panicking. That leads to a bombardment with the court through a flurry of motions. When we get motions, we try to stay the case. We try to act on them. It requires clerk staff to prioritize every one of those motions before anything else that the court does. So you can't even have the clerk process a tenant's affidavit contesting an eviction notice because they're too busy processing these motions on the back end. And they process these motions on the back end, and you could have a deputy constable who's, halfway through his day and on his route. He may have already conducted the lockout by the time we're even able to catch up with the paperwork because there's so many motions that are filed. That, unfortunately, that's been executed on. It's done. There's nothing at that point that anyone can do to stop that because it's already happened. Alternatively, sometimes they're on their way and it's literally like having the bat phone where you have to call, or the court's emailing the constable's trying to get the deputy in the field saying, no, stop on that one, there's a motion. And then 2 hours later, like, okay, the motion's been ruled on. That process is it's untenable. It is so, it's just so feverish at that time. And that's, obviously it ebbs and flows with the time, the month, when notices are served. And after the 7th time, there's kind of the busy weeks of evictions. That's a lot more difficult to manage. So the Civil Law Self-Help Center is just bombarded at that point. The clerk staff is trying to prioritize and juggle all of their priorities. Constables are being redirected in the middle of their routes, and we're trying then to re-engage with social services. That's what we really need to be doing. But we're putting so much duplicate effort onto these cases that whole post-order situation is something that we're hoping we can fix. If we can really get the tenants engaged in the front end, then they can hopefully get connected before this ever happens. The other problem that this ensues is, as you can imagine, even if we're able to, in this 24-hour period between the order and the lockout, stay the lockout for that period of time where we're ruling on a motion and reviewing the motion, even if we're able to do that, and we get that tenant and we realize that tenant might need rehousing. Let's say that eviction is going to go through for whatever reason. Social services can't act in 24 hours. They can't. It's just not enough time to rehouse anybody. So we really need to, again, focus on that front end of the process. So our goal number 3 is to either create court rules that will provide procedural changes and promote eviction diversion and that tenant engagement on the front end, work with legislature. So we're really appreciative of being invited today to even address this and share this vision with you, because it may require, and I think it really will require, some procedural changes, maybe legislatively. So we're working together with some ideas. Jim Birchtold and I met the other day to kind of discuss how do we go about this and how do we make those recommendations? So we're really excited to work with the legislature on this area and provide some proposals with some legislative changes that might enhance an eviction diversion program. And that is all I have on the presentation, and I'm very happy to answer any questions.
Thank you so much, Judge Saragosa. That was emotional, a lot of information, but I think it's what this committee really needs to hear. So first, we will go to anyone that may have questions on Zoom. And I've been told that Senator Pickard has questions. Go ahead, sir.
Thank you, and thank you, Judge, for your presentation. I just have a couple of quick questions. Well, one question. I'll ask it in a couple of parts. And just by way of reference, when before I focused on family law, I did a fair amount of landlord-tenant work, mostly focusing on representing tenants. In any event, you suggested that we should know how many of these summary eviction notices are posted. Now, I've heard for years that there are vastly larger numbers of notices posted than those that receive a response and appear before the courts. So I'm wondering, how do you envision getting that information? Is this through a self-reporting process that the landlords are required to do? Who pays to compile that information? And is the court volunteering to do this work?
Our vision is that the landlords would have to file the notice of eviction with the court before it is served. And that would kind of give it the court-filed stamp, which would give it that auspice of officiality for a tenant to respond to. So in terms of setting that up, it would be a filing. We don't anticipate charging a fee for that filing because it is more of a data collection mechanism. So that is our vision and how we would collect that data, not necessarily self-report. But I do agree with you. The anecdotal stories that we hear from our other stakeholders, and if you noticed on the very first slide of our stakeholders, the Nevada Realtors are our stakeholder, Multi-Housing Association, Apartment Association is also one of our stakeholders. So they're engaged in this process as well, and they support this concept of having those notices kind of come through the court. But anecdotally, we have heard that the cases that we see, and when we're talking Las Vegas Justice Court sees about 30,000 a year, and we're on track for 45,000 for fiscal year 22, it's about 10%. What we see is 10%. That's what we hear. So you're talking a large number, as the senator just pointed out, of what's actually served. And we don't know.
Sure, and that's ultimately my concern. It's how do we manage this? If you're getting 30,000 and that's just 10%, holy cow! I don't know how the court's going to be able to manage even just the filings. I know the courts currently are just burgeoning with filings and difficulties in dealing with it. I know in my discussions with the county IT department that getting Tyler Technologies up and going with all that they've done has been difficult. And I can only imagine if you get, upwards of, 300,000 filings all of a sudden every year, you're going to be hard pressed to just handle the data aspect. But let me ask you another question. It has to do with your CARES team approach, similar to what the county's doing. I'm wondering, the thing that popped into my head when I first reviewed the slides was, do we have a separation of powers issues to the extent that it looks like the court is undertaking some social support for tenants? I recognize, in your presentation, you mentioned that they would be staffed by others, but if the courts are taking on the responsibility to make sure these parties are routed through a new social program, essentially. Is there any concern that, well, let me ask it this way. Is there an analog to a similar but different program that we have existing that has proven to be okay?
This is Judge Zaragoza. I think that's a good question. I think that in terms of specialty courts, I mean, we do a lot of work in the criminal realm with specialty courts in rehabilitation. This is a little unique. It's not necessarily a specialty court in that construct, but we do have social workers. We do have court coordinators that are social work trained that work with our specialty court programs. So I don't necessarily think that simply by employing someone who has that skill set that we're crossing those lines. But we absolutely need to have some mechanism of sharing information. Because
Sure, and
rental
I
assistance is not going to
completely
go
agree.
away. We need to be able to share that information. So I don't necessarily see it as a crossing those lines, I guess.
All right, and I agree. Sharing the information is going to be critical. Of course, in the specialty court situation, the county undertakes the social service side. The court provides just an avenue to divert off to this other program, and then the court doesn't lose jurisdiction over the case. It's, as you know, it usually a hold open or some other mechanism where it just stays pending until the program is adhered to. But that's voluntary up to the individual, whether or not they actually participate in those programs. Whereas what you're describing seems, and maybe I'm just reading the wrong things into your presentation, but it seems that this is actually under the auspices of the court. The court is now operating, bringing in these other division personnel, but they are operating this program, and that's where I think we might run afoul. Obviously, we haven't had a chance to talk to LCB Legal about that, but that was the first thing that came to mind. I want to make sure if we implement this and we fund it, authorize it, and then fund it at the state level, we're doing it in a way that's constitutionally sound. That's all, Madam Chair.
Yeah.
Thank you, Senator. Judge Zaragoza, do you have any further follow-up to his statement?
Thank you, Assemblywoman Summers Armstrong. This is Judge Zaragoza. I don't think I have any other further follow-up now. I mean, I think he raises a good point, and we definitely want to make sure that whatever we're doing is constitutionally sound. I mean, there are some areas where we have to, hold hands between branches of government, and I hope that this is one that we can do that and stay within our boundaries. And that's one of the reasons that the case workers, the family services specialists who are identified on the CARES team, are actually executive branch employees who are just kind of assigned to this program to provide that case management aspect for the individual tenant. And having an eligibility specialist as kind of the court employee is not all that uncommon either. I mean, we use those eligibility type specialists in many aspects of the court. So I agree it needs some further look, but I think it raises a good point, and we'll make sure that we look into that. There was one other thing. When we get to an appropriate point, you had asked for some data in your, I talked to one of the assistants, and so I did have a little bit of information on that as well. So whenever the time is appropriate.
Thank you so much. We'll go to more questions, and then we'll come back to the data information. So at this time, I'd like to go to Northern Nevada. Chair Scheible, is there anyone up north who may have questions?
Chair, Assemblyman O'Neill has a couple, if I may.
Yes, Assemblyman O'Neill, please go ahead.
Thank you. Judge, it may be an unfair question for you, and we've been talking about Las Vegas, Clark County. It's a nice system. Do you have any information or how this could be duplicated out to the rurals? How are the rurals we haven't even spoken of Washoe County, which I know has probably some very similar issues, or just not in the numbers, but we still do have the rurals that have eviction processing. So are you talking duplicating this across the state? Or do you offer anything for the rurals? And if you can comment, I know you're centric down south, so I appreciate it.
Thank you, Assemblyman O'Neill. Judge Saragosa, I think right now we're at such an early stage, and we know that at least with Las Vegas Justice Court, we handle about 70 to 75% of the state's issues. If you add North Las Vegas and Henderson, which would be our next step, and that's been topic of discussion to, once we get this kind of started and fine-tuned and it's working, to expand into those other two. When you add both North Las Vegas and Henderson evictions on, you're talking about 95% almost of the state's evictions. And then you've got Reno. And then you're right, you have all the rurals. So I think what we've really kind of been focusing on is trying to get something up and running that would address this large segment of the community. And then I think once we have something moving and it's working, then we can look to our county for additional funding to start expanding countywide into our rural townships. And I think at that point, if it's something that's successful, then certainly we would want to I would think adopt that statewide, but that's a policy decision for you all. And I'm hopeful that we can produce something that is successful, that we can show you some data points that would show it is successful. And if it is, I think that we would figure out a way to make that appropriate and accessible statewide, even if that's through some virtual mechanism.
Thank you. Thank you, Chair.
Thank you, Assemblyman. Anyone else in Northern Nevada with any questions? Seeing none, I'd like to allow those here in Southern Nevada to ask any questions. All right, Assemblywoman Nguyen.
Thank you. You had mentioned, I know that we had passed some legislation during the 2021 session to protect people that had been evicted during the pandemic from this being placed on, I guess, their record, for lack of a better, determined word for that. But, and you had talked about how you just don't even know how many summary eviction notices because they're not filed. So before they make it to you, you don't. And it sounds like you're trying to capture some of these people earlier on in the process. How does that work in that sharing of information, which I see why you would need, but without creating another unintended consequence where we're now tagging people with this label of being a part of the process that might not have been a part of the process before?
Assemblywoman Nguyen, this is Judge Saragosa. Thank you for the question. I don't know that, at least for Las Vegas Justice Court, and I certainly can't speak for all of our jurisdictions across the state, but we use Odyssey as our case management system. One of the questions was just kind of processing those, I think, from Senator Pickard. And we do have an electronic file and serve system that almost 100% of our landlords use. So in terms of getting that document into the court, it would be an electronic filing that would be automatic, and it would create a case and put it on the case file, or it would create to analogize it to something we do in criminal. Before a criminal complaint is filed and someone is arrested, our court uses a case number that is a pre-complaint case number. And then when the complaint is filed, it converts that case number into what we call a real case number. It's an existing case. So we would kind of set it up in a construct like that, where there would kind of be this pre-case number. And if it did not become a case because there were no filings, it would automatically, after a certain period of time, we would program that in so that it would be sealed. And that's really kind of what happens now. All evictions that are, like in that large number that I showed you on the earlier slide with the green line, where a tenant files an answer, or what we call an answer, their affidavit contesting an eviction notice, It's not a full case yet. Yes, they've done what they were statutorily required to do and opposed or contested the landlord's notice, but the landlord has not filed a complaint. So by court rule, they have so many days to file that complaint. If they don't, that case is automatically, we have it programmed in, it's automatically closed, it's automatically sealed. So it's not on that individual's record for view by anyone. Even my own clerk staff can't view that case. So even my own clerk staff, if a case is sealed, they do not have access. Only the highest level of our division administrators and the judges have access to sealed cases. So I don't think that it would have that unintended consequence of being viewed by, say, a prospective landlord who would then attempt to hold that against them because there was a notice. We would avoid that.
Thank you. I had like heart palpitations because I was just thinking of like a mass number of pre-eviction, like, I guess, records that people would have. And I know that we already struggle with the automatic sealing of any record in this state. So I would hate to see a bunch of people that normally wouldn't be captured all of a sudden now a part of that like process. I'm just kind of following up on something that Senator Pickard had said about like other specialty courts, like something analogous to what we're trying to accomplish here, what you're trying to accomplish here with the eviction diversion court. It's my understanding, and I know that you have been a part of some of these specialty courts, including kind of a similar program with the Veterans Treatment Court, because it is more holistic, dealing with things like housing and PTSD and mental health and addiction and all kinds of like other wraparound services. It's my understanding, and I don't know if this is true, but we already have those in statute. So the courts and even the judge is often a part of that treatment team. Isn't that the way it works in other specialty courts?
Yes, Assemblywoman Nguyen, this is Judge Zaragoza, that is correct. The judge is kind of part of that team in terms of, I guess we call it a case management team, but it really is. And it includes public defenders or private defense attorney, whoever is representing that criminal defendant, the DA. It also includes our court coordinators who are, in essence, social worker trained. Some of them are social workers, some of them have that background, and the court. And oftentimes the treatment providers will provide update and information so that we can, exactly like you said, provide that kind of wraparound service or resources for an individual.
Thank you. And so in statute, there's already some clarification that's in there that allows the judge to not only be the adjudicator, but also to participate in that unique program where everyone's working collaboratively. Is that correct?
Assemblywoman Nguyen, this is Judge Zaragoza. I'm not positive that that particular point is in statute. Certainly there are statutes that authorize the court to operate a drug court program, a mental health court program, a veterans treatment court program, and all of those various specialty courts, DUI court programs. So there's certainly statutory authority within those programs to operate them, and that they fall under the courts. But specifically whether there is this idea of a case management team that the court or the judge becomes involved in, that's more comes from evidence-based best practices across the nation and handling those courts. So you have the National Drug Court, I can't remember the acronym now. Anyway, there's a national association that, National Association of Drug Court Professionals, there it is, NADCP. They are really the spearhead of creating best practices based on evidence-based data analysis. And so those best practices are inclusive of the judge cooperating in those case management teams.
And then I guess my final question is in order to like implement this, do you feel like you have the like authority, or would you need more legislative authority or enabling language to allow any of the courts, whether it's statewide or on a local basis, to be able to engage in this new kind of eviction diversion program?
Assemblywoman Nguyen, this is Judge Zaragoza. I think that we have the authority to kind of handle our cases. We always have the authority to kind of refer cases to mediation, things like that. There's no specific statutory language in Chapter 40 that exists now that would prevent the court from doing something like this. In fact, there's nothing in Chapter 40 that even says we have to hold a summary eviction hearing within a certain number of days. We generally, prior to pandemic, would hold those in 7 to 10 days. Obviously now that's a different construct because we do defer those out for mediation. And we've done that. The mediation program was established by Supreme Court rule. And I think this is kind of just an arm of that kind of an idea. I think the courts could go ahead and do that through either rule changes, things like that, because we would not be running afoul of any existing Chapter 40 procedural requirements. We would not be changing any of that. Now, whether those things changed in the future, that's a different issue for the next legislative session or beyond, but we would definitely not be doing anything that would run afoul of existing statutory guidance.
Thank you. I don't have any other questions.
Thank you very much, Assemblywoman Nguyen. Before I ask my couple of questions, I'd like to give everyone, I see on Zoom, Assemblywoman Krasner has some questions, so please go ahead. Thank you.
Thank you very much. Thank you for your presentation, Judge. So just a couple of questions that relate a little bit to Assemblywoman Nguyen's questions. So you did say that currently the eviction process in Nevada does not go through the court. It goes to mediation. Why not just continue having the eviction process go through mediation and maybe just adjust the mediation process if that needs to happen? Because I do have a concern that if it goes through the court, there will be a record. Somebody's name's going to be on some record. We're really trying not to create more records for people of having them be a bad person because they can't pay their rent, or letting landlords have a place where they can go and look at this data collection system you mentioned where information is shared and then they'll know who not to rent to in the future. So I'm wondering, why don't we just fix the mediation system, leave the court out of it so the person doesn't have a record if we care that we're not trying to create records for people. Thank you.
Assemblywoman Krasner, thank you. This is Judge Saragosa. I think there may be some misunderstanding. The existing mediation program and all summary evictions do go through the court. The one aspect that isn't in the court right now are the initial notices. So all eviction complaints, all eviction tenant contesting affidavits that we refer to as answers all go through the court. They all create cases, and no case goes to mediation until there's both a complaint and an answer filed in a case. And that is what triggers the court to refer it to Home Means Nevada for mediation. That case is already in the court system. It's already a case. So we refer it to mediation, and then once the mediation is done, we wait for the mediation program through Home Means Nevada to then send us a report of what happened at the mediation, whether the party showed or whether they reached a settlement, whether they didn't. So all of that is already in the court system. The one piece that's not is the initial notice. And I through the brain trust of all of the stakeholders that deal heavily with summary evictions day in and day out, we've had many discussions on, what is the best mechanism to how do we address this issue? And early tenant engagement is really what we keep coming back to. And so what we hope to do through this program is, instead of having the mediation program housed kind of somewhere else, the mediator or a mediator would be right then and there as part of the eviction diversion. So when the individual shows up, they can sit down with a mediator right then and there, and they might need to continue that for further sessions, but at least you'd have that initial engagement with both landlord and tenant over mediation issues. So you could see, one of the things that we struggle with a lot is landlords don't don't understand rental assistance and the way Assembly Bill 486 was written, that it really mandates that the landlord participate in the process and be engaged and accept the rental assistance. So what has happened is if a tenant is authorized rental assistance, then if the landlord is not cooperating, the Clark County Social Services will cut that check directly to the tenant, and that money does not go to satisfy their rent. It doesn't save any eviction, because unless the tenant voluntarily turns it over to the landlord and the landlord then accepts it after the money has been granted or the rental assistance application has been granted, there's still a non-payment of rent, and there's still then, granted that that particular eviction is going to be denied because the landlord didn't cooperate, but then they're just going to file a new one. So it's not really solving an issue. It's just another eviction on another day, another case in the system to process, instead of trying to resolve that at the earliest possible setting. I hope that answers your question.
It does, but so currently the initial process, and I'm not super familiar with this, is that when the landlord just goes and puts a notice on the tenant's door, and then the tenant has some period of time to pay before it goes to court? Is that the current process?
Yes, Assemblywoman Krasner, this is Judge Sergos again. Yes, that is the process. So depending upon the type of eviction, the landlord has to initiate action with a notice. In the non-payment of rent scenario, they have to serve the tenant with a 7-day notice to pay rent or to surrender the premises, possession of the premises. And within that same period of time, if they feel the notice is improper, they contest it by filing an affidavit with the court that we call the answer, and that opens a court case. They have to do something to respond. So sometimes they'll be given a 3-day notice that tells them you've committed a nuisance, you need to surrender the premises. Sometimes it's a 5-day notice that you've committed a lease violation and you have 5 days to either surrender the premises or to fix the problem, whatever that violation was. Sometimes it's a 30-day no cause notice. So the initial step in any eviction is for the landlord to post that notice. Subsequent to that, the tenant has that period of time to act or to file something with the court. And then after the period of time for whatever notice it is has expired, the landlord can come in and file the complaint.
Okay, just one more follow-up. So if the landlord puts the notice on the tenant's door, pay rent in 7 days, or I'm going to file with the court, and the tenant cures by paying the late rent, then nothing is filed with the court, and then there is no court filing, there is no record for the person. It's just cured. Is that correct? Currently?
Yes, Assemblywoman Krasner, that's correct.
Okay, so that would actually be better for an individual, wouldn't it? I mean, why do we want to just start creating records for people on day one? Shouldn't we at least give people a week to come up with money? Or it seems like that part of this is actually better for an individual who might just be a little bit late with their rent.
Assemblywoman Krasner, this is Judge Sergosa. We don't intend to change that process. We still want to give that person that same number of days to take that action. We don't intend to change that process at all at this point. What we really are hoping is that during that 7 days, that if the tenant is unable to just by themselves just satisfy and pay the rent, that they would then be connected with a lawyer, with legal assistance. They would be connected with resources. They would be connected with rental assistance, where if they provide all of the documents they need, that family services case manager could approve or deny their rental assistance application on the spot without any delay. So within that 7 days, so that they would be able to cure through rental assistance or otherwise. So we don't intend to not give the tenant that period of time, but what it does afford us is, and we've talked a lot about, I've listened all morning today about data. We just don't have the data, and Clark County Social Services doesn't have the data to even know what they need to respond to or what the problem is. Or those individuals, the other way that they cure is they just leave. And then where do they go? Where does social services fit into that piece of the puzzle? They never come through the court. We don't know whether they go to social services or not to find rehousing assistance. So the idea is just to engage them at the earliest possible stage, but not to take away their ability to be able to cure within the statutory time period. We still want to provide that. And I'm confident in our court system that those notices will be automatically sealed and that they would not be revealed to prospective landlords and the like. Obviously I said I cannot speak for other jurisdictions, but I know that that's something that's programmed in, and we already do that for the thousands of cases that I showed where there's an answer file but no complaint, and we seal and dismiss, or we close and dismiss, or close and seal, those cases. So I'm confident in my system that would not be a problem.
Okay, so just want to follow up. When you first began speaking to us, you said that currently people don't know what's going on because the landlord just puts the notice on the tenant's door, and until that period of time passes, let's say it's 7 days to cure or pay rent, it's only after that, when the landlord goes to court, that it is actually filed and there's a case, a complaint is filed. But prior to that, there's no record. There's no record. The court has not received a complaint. What you're trying to do is start that process on day one with the court. Is that correct? Is that what you said initially?
That is what I'm saying in terms of the landlord's notice, that we want that notice to come through the court for data collection purposes, as well as because if it comes through the court and bears some sort of official file stamp, those types of things that make it look official, we feel and I'm going to let Mr. Birchtold, who I know is up there speaking after me, address that even further, because he is boots on the ground dealing with the Civil Law Self-Help Center and the staff there, and he has individual engagement with tenants to understand what their barriers are to even contesting the notice. And one of those is it doesn't look official. We don't think it's real. It doesn't have a court filed state. It's not filed with the court. So I think we lose a lot of tenants even in the process because they don't think it's real. And I think that Mr. Birchtold would be able to kind of address a little bit more even of why we think this avenue or this proposed plan will be beneficial to a tenant.
Okay, and just one last thing. So that is my understanding then. The person currently will have that week to pay and cure, and it's not going to court. No complaint is filed. With your proposal, on day one, it gets filed with the court. The complaint's there. It looks official, all right, but it is creating a record for the person. And you think it might get sealed. And then once again, we're back to everybody has a record. We're creating records for everybody. Landlords can find out who never to rent to again. I just have some concerns.
Assemblywoman Krasner, it's not the complaint that would be filed. It's just the notice. It's the notice of eviction. So yes, you are correct. It would give it a data record in the court system, and I don't dispute that at all. But it's not a case yet. It's not the complaint that gets filed initially. Under our current statutory scheme, we would not disrupt that at this point, although I think we would ultimately propose that we switch this around so that landlords do something first, and it's not the tenants who are opening up a case, because that's just a little weird. But it would not be the complaint. The landlord would still have to wait until that notice period expired. The tenant would still have that same period of time to respond to the notice in whatever manner they want, whether that's currently to pay, to surrender, or to contest. And then after that period expires, then the landlord would file the complaint. So if the complaint isn't filed, it's a record that would ultimately be sealed if the complaint is never filed, but it would not be an eviction complaint at that point.
Thank you, Judge Zaragoza. And I would advise Assemblywoman Krasner, if you have additional questions on this issue or need further clarification, that we ask Judge Zaragoza to get with you offline so that we can get you whatever additional information that you need. This is very complicated. I'm just learning as I'm going along here as well, and have everyone, I think, has similar concerns. And so we just want to make sure that we are clear moving forward. Does anyone else have a question? Okay, I don't see anybody's hands raised. I don't see anyone waving at me. I would just want to ask one follow-up question before you give us the data. And that question would be, do we know whether or not the larger agencies have their own databases that they are collecting and using this data? It may not be an official one that goes to the credit reporting, but internally. Do you know in your conversations if they collect data?
Assemblywoman Summers Armstrong, when you say the larger agencies, what do you mean?
Folks who are members of the apartment association, or if they're members of if they're members of the realtors, do they have this data themselves?
To my knowledge, no, because they're so diverse and they're so scattered across the state. They do not have any particular clearinghouse that stores and gathers that data. I mean, you have so many eviction services that are acting, on just doing the eviction part. Then you have property managers, then you've got owners, and you've got individual owners and multifamily owners. It's so spread across the state. It is my understanding they do not keep any of that data on their own. It's just anecdotal.
Thank you so much, Judge Zaragoza. Could you just give us that data that you have very quickly, and then we'll move on?
Yeah, very quickly. And I didn't mean to hype it up, because a lot of it is, I don't have what you want. So one thing I did want to add is that in addition to the CHAP program in Clark County that my slides had some information on, again, I want to reiterate, that is not CHAP program wide. Those are only the cases that the court has referred to the CHAP program. There are thousands of additional applications that are made for rental assistance that never come through the court. And so they have given out far, far more money than what I have reflected on my slides. Mine were typically just with the court. But there's also a rental assistance for tenants program with the city of Las Vegas, and I wanted to give you some numbers for them. They have no longer been accepting applications since October 29th of 2021, but they did have 3,222 applications, of which they approved 1,997, and they distributed $13,872 in rental assistance. So that's another program that was in the city of Las Vegas. And the only other thing is, I did have specific questions that you were inquiring, like which demographics of our community are impacted most, if we had anything on that. And while I didn't mean to give false hype, we don't collect demographic data in summary evictions. We have no idea of any sort of racial, ethnic. We don't keep we don't collect it, we don't keep it, we don't know it. So I don't have that information to provide that would offer any assistance. We also don't keep it by zip code. Now, I do know that there are a couple of different individual programs out there. There's one called Eviction Lab, and I don't recall the name of the other one. Mr. Birchtold might have that information because he shared it with me, that they basically come in and they mine data from the court. We give it to them, and then they run their list and run it by zip code, or really more through some sort of precinct. So they have some data on that would give you geographically those segments that are hit the most with evictions. And then the third question you asked was with respect to our veteran population. And we don't have that information. I don't know by the way the documents are filed, whether it's a tenant's affidavit or a complaint, whether a person falls within that category or not. The one thing that I did do was I reached out to Nellis Air Force Base through their legal office. I have a good working relationship with them to inquire. We, in the military and the JAG world, I say we because I'm a military reservist as well, we keep data on every single legal assistance appointment and the reason for it. So I gathered that data for the last calendar years 19 through so far in 22. But the only thing I can count is the number of people that came in for legal assistance for landlord-tenant issues and what their rank was. But legal assistance is only offered for active duty service members and or retirees. It's not offered to every veteran, so it's such a small snapshot. In all that period of time, there were 221 legal assistance visits, the majority of those for active service members versus retirees. And the majority of those, 87 of those, were of individuals in the rank of E1 to E4, which is our lowest enlisted ranks. So I'm sorry I can't provide you more information, but that was the, and that was only Nellis, not Creech, at least a snapshot.
Well, Judge Zaragoza, I really appreciate your diligence and at least trying to get those data points. And maybe as we're going forward, this would be some areas that we might need to add into the data collection to get a broader picture, because these are issues that are throughout our community. They're recurring. And so we probably need to address them. So, ma'am, if you don't have anything else to share with us.
I appreciate it. The only, I don't have anything else on the eviction. I did have just a couple of comments that I just, if it's all appropriate to inquire of Chair Scheibel. I sat through all the presentations this morning. I just had 2 or 3 little points that will take me less than a minute to share that I thought might be helpful to you to know.
Please go ahead. You've been here all day, so go right ahead.
I wanted to touch base on the issue of the misdemeanor citations and the like that was presented, and the data that was, there was 18,436 total misdemeanor cases in Las Vegas Justice Court. I've done that research before to determine how many are citations and how many are arrests, and it's about 50-50. It's been pretty consistent. Of that, so you'd have about 9,200 that are citations versus actual arrests. And I can also tell you that in the last 2021 fiscal year, there were 3,806 domestic violence cases that were part of those arrests, 3,071 DUI cases that were those arrests, and then there's 3,101 crimes against the person. So the majority of those arrests on citations are falling within that category, and everything else is citations. So we do have a lot of citations. I just wanted to share that. The other thing I wanted to share with respect to the pretrial is the Las Vegas Justice Court does use a uniform bail schedule from the moment there's an arrest. There is a bail schedule, so someone can post their bail immediately if they are able to. We also use an administrative OR order that's been in place for almost 10 years now, probably longer. We are in the process of, in Las Vegas Justice Court has a pretrial services division, and we are working to implement AB 424 by offering pretrial services. We've been doing that for a little while, but we're expanding that to all of our county. And with that, we are establishing a joint administrative OR order, so that's in the works. We do use the JAVS program for our recording, and I think that's pretty consistent across the state. Data collection is a problem for everyone. We all do use the Nevada pretrial risk assessment tool as part of a Supreme Court ADKT administrative order, so we all across the state use that. And the one last thing I wanted to share was, while the Kentucky has 220 plus staff and employee to service the entire state of 4.4 million, Clark County has 44 employees to address and provide services for 2.3 million, which is really a challenge. And that includes all of pretrial supervision, and we have no funding that's made available to us for any sort of pretrial supervision, drug testing, or rehabilitation, any treatment or the like. So I thought I'd share that information as it pertains to those other issues, and if there's any further information you need, I'm happy to provide that at any time. Thank you.
Thank you very much. That certainly closes a few gaps that were left from the earlier presentations. So thank you so very much, Judge Zaragoza. We appreciate you sticking in here all day to give us this information. Next up on my list of presentations is Jonathan Norman of Statewide Advocacy Outreach and Policy Director for the Nevada Coalition of Legal Service Providers. Is Mr. Norman with us today?
I am. Thank you, Chair.
Thank you, Mr. Norman. Are you ready to go forward?
I believe so.
Thank you. Go right ahead.
Chair Summers Armstrong, members of the committee, thank you for having us here today. My name is Jonathan Norman. I'm with the Coalition of Legal Service Providers for the state of Nevada. I'm joined by Jim Birchtold, who is the directing attorney for the Consumer Rights Project at the Legal Aid Center of Southern Nevada. I did want to comment just for a moment on the diversion court, because I know the Legal Aid Center has been very involved in that and with Judge Saragosa, and I want to commend, her leadership on getting, she's had the Legal Aid Center, the Apartment Association, and the realtors working together for the last year on this problem, and I think that says a lot. And I also want to commend the work of Kevin Schiller and the Clark County's team there with Randy Reynoso and Tim Birch, because it's been a heavy lift to see what can be done for people facing eviction and imminent homelessness, and this team comes at it with let's solve the problem attitude, and I think that's great. I also wanted to make the point that the reforms to Chapter 40 that will help diversion court are common sense reforms that will help every Nevadan, whether they have a diversion court in place or not. So I think the things that will help diversion court are common sense reforms that need to be put in place whether we had a diversion court or not. The Pulse survey is a survey conducted by the Census Bureau, and I looked at the latest one. I think it has a lag time of about 2 weeks. And in Nevada, we have 100,000 families that are behind on rent and face risk of eviction. 5,500 of those report having a member in their home over the age of 65, and around 60,000 report having children in their home. The housing crisis has a lot of threads. I was here for the Interim Finance Committee where the Home Means Nevada program passed through the $250 million allocation. And in that testimony, there was a UNR student who he testified that he was homeless, living in his car while he was pursuing his education. Recently in Clark County, there was a news story of a CCSD teacher who is living in her car. She has paid over $1,000 in application fees trying to find an apartment. And then when I think of the Coalition of Legal Service Providers, they provide services to the most vulnerable people, which typically are not students and teachers, right? So if students and teachers are struggling in this environment, the people on fixed incomes, families with children, and people in poverty are in that much worse of a state. And it's there's rising housing costs. Rents are going out of control. There's a lack of affordable housing. But when it comes to Chapter 40 and summary evictions, it really is kind of a self-inflicted harm that doesn't advance any purpose having the system we have. And I think there was testimony in the public comment today that kind of addressed the harm that it does to a family. I think there was a Miss Barry, and then I think also Plan testified about the harm that summary eviction does. It's not just the loss of that home, it's disruption in school. It's often comes with a loss of personal property if a lockout happens. Everything cascades from there, and we heard from the Fines and Fees Justice Committee where a lot of these people end up after they're evicted is they often end up in transitional housing or homeless, and then the years that it could take them to dig out from an eviction, right? So they start an eviction, they're homeless, they pick up fines and fees, and their life trajectory is changed forever, and it damages our entire community. The two things that strike me about the summary eviction statute are its speed, it's a rocket docket, and its confusion. And I want you to keep those in mind as we work through the presentation. And I'm going to turn it over to Jim Birchtold to walk us through the slides. Thank you.
Good afternoon, Chair and members of the committee. I know you've been waiting patiently all day for this presentation, so I'll get right to it. Honestly, we're zooming out a little bit from Judge Saragosa's presentation, and I was asked to give an overview of summary eviction and kind of the history of how it's changed over the last 2 years. So in retrospect, it probably would have made more sense to do this before Judge Saragosa's presentation rather than after, but we will trudge through it nonetheless. So it really is impossible to talk about summary eviction without talking about the last 2 years and how the pandemic has impacted housing generally and the eviction process. So next slide. So just to paint that picture, back one. To paint that picture, so January 2021, we are about a year into the pandemic. At that point, some 15 million people across the country, 15 million renters are behind on rent. That's 1 in every 5 renters in the country. By the fall, it wasn't much better, despite the government's activity and despite the government's efforts to try to address this issue. Only still, 1 in 6 renters are behind on rent. It was widely recognized at all levels of government that there was a crisis. It was often referred to as a pending eviction tsunami. And this wasn't just about people potentially getting evicted and spreading COVID. It was also about what happens after the pandemic. In July of 2021, United States renters owed some $20 billion in back rent. That is a number that those renters would never dig out from. They would never recover from that financial impact. It was also becoming a social justice issue. Communities of color, minorities were being evicted, were behind on rent at 2 times the rate of non-minorities. Black women, for example, were being evicted at a rate 4 times the rate of white men. And of course, Nevada was not immune from this. Nevada was hit, in fact, harder than many states across the country. In July 2020, at the beginning of the pandemic, the Gwynn Center estimated that over 118,000 Nevadans were at risk for eviction. About 1 year later, that number proved accurate. June of 2021, 128,000 renters in Nevada were behind on their rent. So, how was this addressed? There was a response at the federal level, which I'll walk you through. Many of you probably already know this, but right out of the gate, the federal government comes in and passes the CARES Act. The CARES Act did many things, but one of the things that it did, it had a limited, very limited restriction on evictions for certain types of properties. The CARES Act expired in July of 2020, although there are some lingering protections. Although the CARES Act is gone, some of the federal agencies have continued those protections, and I'll touch on those in a minute. Just as a side note, there are really 2 hallmarks that I want you to pay attention to as I go through this history. One is everything that happened during the last 2 years happened in 3 or 4 month increments. Because if you remember, back in 2020, this would never last for more than 3 months. So during the pandemic, every 3 months there was a change, which leads us to the second hallmark of what happened during the pandemic, and that is utter confusion. There was no way for people, even experts in the housing space, could not keep track of what was happening with evictions and with housing. So tenants and landlords were utterly confused about the process, the protections, and what was happening. So the CARES Act expires in 2020, July of 2020. President Trump issues an executive order directing the CDC to take a look at whether there needs to be some moratorium, some restriction on evictions to prevent the spread of COVID. The CDC takes action and implements an eviction moratorium. That moratorium is in place until August of 2021, when it's eventually struck down by the Supreme Court. Now, during the time that that moratorium is in place, it starts out pretty good, and then over the course of the moratorium, it gets weaker and weaker and more confusing until by the end, it's really offering very little protection at all. Now, while this is all happening, Congress is also taking action. So in December, that's actually 2020, in December of 2020, Congress passes the Consolidated Appropriations Act, followed by the American Rescue Plan in March of 2021. Now, what those two acts did is they allocated $46.5 billion to the states to get out onto the streets and get that money into the hands of the landlords. $480 million of that money came to Nevada. That money is being distributed through a program called CHAP. It was originally the CARES Housing Assistance. Now in Clark County, it's the Clark County Housing Assistance, Reno Housing Authority, Rural Housing Authority. But keep in mind that there was no mechanism to get that money out the door. So those agencies are literally building that plane as they're trying to fly it. There was also a response at the state level. At the state level, the governor almost immediately issued an emergency directive limiting evictions through various forms. That those executive orders were in place until the last one expired in May of 2021. There were three real pieces of legislation that impacted evictions, and especially summary evictions. SB 1 was passed in the special session at the very start of the pandemic, and then again in AB 46 2021, eviction mediation was created. The program really created an opportunity for landlords and tenants to sit down with a mediator and try to come up with creative solutions to resolve their issues and avoid an eviction. That was implemented by rules from the Nevada Supreme Court and administered by Home Means Nevada. It is still in effect as part of the eviction process. It is set to expire in June of 2023 or when the money to operate the program runs out. The other big piece of legislation was AB 486. AB 486 was designed to coordinate rental assistance with Nevada's very fast eviction process so that people weren't getting evicted while they were waiting for their rental assistance applications to be processed. Now, it did this in two ways. It created two affirmative defenses that a tenant could raise in the context of an eviction case. One of the affirmative defenses was, I have a pending CHAP application. I have applied for rental assistance and I am waiting for a determination, in which case the court could stay that eviction until that application was resolved. The other affirmative defense was, I have received rental assistance, or I have tried to get rental assistance, but my landlord either will not take the money or will not cooperate in the process to allow me to get it. And again, that case could be stayed until that issue was resolved. The other piece of legislation was AB 141. AB 141 automatically sealed any eviction for non-payment of rent that was granted during the state of emergency. So as soon as the state of emergency ends, AB 141 no longer has any power. Excuse me. So with all that background, let's talk about evictions in Nevada. So there are really two types of eviction procedures in Nevada. There's the summary eviction procedure, which is contained in two sections of Chapter 40. 4253 and 4254. Then there is what is commonly referred to as the formal eviction process, which is contained in a number of sections also in Chapter 40. The difference between the two, as the name sort of indicates, summary eviction is a fast process. It is designed to be simple so that landlords can maneuver and navigate the process themselves without an attorney. Importantly, though, the only thing that can be awarded in a summary eviction case is possession of the property. So there are no money judgments awarded in a summary eviction case. It is just about who gets possession. Now, I want to emphasize that while The process is relatively simple and straightforward. That is simple and straightforward for the landlords. For the tenants, it is a very confusing process, which I'll touch on later. The formal eviction process, in contrast, is like any other civil court case. It can be lengthy. There is a right to a jury trial if one is requested. Most times it will require an attorney to navigate that process, but you can obtain not only possession of the property, but also a money judgment in the case. So let's focus on summary evictions. I've tried to break summary evictions down into 5 steps that I will go through. Step 1. As Judge Saragosa indicated, every eviction in Nevada starts the same way, by the landlord giving a notice to the tenant, telling the tenant what the landlord believes the tenant is doing wrong. Now, each notice has a different length depending on the basis for the eviction. Some notices are 1-part notices, some notices are 2-part notices. So, non-payment of rent, that's a 7-day notice, although there currently is a 30-day notice for non-payment of rent as a result of one of those lingering CARES Act protections for a very small sliver of properties. All other notices are 2-part. So for a nuisance, for example, the tenant would get a 3-day notice telling the tenant what the believed nuisance is, and then they would receive a 5-day notice. Lease violation is a 5-day followed by a 5-day. A no-cause eviction is the landlord essentially telling the tenant, it's not that you're doing anything wrong, I just want the property back. That's a 30-day notice for a monthly tenant, a 7-day notice for a weekly tenant, followed by a 5-day notice. There's also something in Nevada called a tenancy at will. Think of a tenant at will as the guest who stays too long and you can't get rid of them. That's kind of what a tenant at will is. That's a 5-day followed by a 5-day. Now, so every eviction starts by the tenant getting one of these notices. Usually it is taped to the tenant's door. It is prepared by the landlord and usually served by the landlord. So as Judge Saragosa said earlier, tenants do not believe these notices are real, but that's the actual mechanism that starts the legal eviction process. So step 2, once the tenant receives that notice period is the tenant's window to take some action. And there's really only 4 things they can do. 1, they can fix the problem. So let's say it's a non-payment notice. The tenant can pay the money. If the tenant fixes the problem, there's no reason, there's no basis for an eviction to go forward. The second thing the tenant can do is leave. The tenant can receive the notice and just vacate the property. Again, no reason for an eviction to go forward because the landlord now has the property back. The third thing the tenant can do during that period is if the tenant disagrees with the basis for the eviction, the tenant can go down to court and can file an affidavit, commonly referred to as an answer, file an answer with the court. And what that answer does is guarantee the tenant a hearing. So no eviction can take place until that hearing. The fourth thing, which actually isn't listed on here, is the tenant can do nothing. The tenant could take no action in response to the eviction notice. If that happens, it is likely that the tenant will be evicted by default, meaning the court will review the landlord's filings, issue an eviction order, the eviction order gets posted on the tenant's door, the constable or the sheriff will come back the next day, usually 24 hours, and lock the tenant out. So step 3 and 4, after the eviction notice, after that time period runs, then it's the landlord's chance to take action. The landlord can now go to court and file a complaint with the court asking the court for an eviction order. What happens next depends on what the tenant did during the notice period. If the tenant did nothing, did not respond to that notice, then again, the eviction is granted pretty much by default. The court does a review of the landlord's filings. If everything is in order, the eviction order is issued. It is sent to the constable. 24 hours later, the tenant is locked out. If the tenant did do something, if the tenant during that notice period went to the court and filed an answer with the court, then the court will schedule a hearing. Now, those hearings are under AB 4886. Those hearings are set out at least 30 days to allow for mediation to happen. So If one of the parties has requested mediation, the case is assigned to a mediator. If the mediator is able to resolve the case with the parties, the case is usually dismissed. If it's not resolved through mediation, then the case goes to hearing and potentially an eviction is granted. If the tenant has raised an AB 486 defense, I've applied for rental assistance, then the judge will verify that that application is pending and stay the case. If the hearing is held and the court denies the eviction, then the landlord really has two options. The landlord can issue another eviction notice and start the whole process again, or the landlord, can file for a formal eviction. So, if the eviction is granted, again, the court will issue the eviction order. The eviction order gets sent to the constable or the sheriff. The sheriff will post the order on the tenant's door, come back the next day, and lock the tenant out. There's very little the tenant can do at that point. The tenant can try to appeal the case. To do so, they have to pay a filing fee and post a $250 bond, or they can try filing a motion to stay the case. They run down to the court. When they receive that eviction order, they file a motion with the court asking the court to grant them some additional time to leave the property. And that was the chaos that Judge Saragosa was talking about earlier. So let's talk for a minute about, that's really the totality of the summary eviction process. But let's talk about some of the issues with that process. First, the notice. The notice, as Judge Saragosa said, happens outside the court system, so it is impossible to track how many notices are actually issued at any given time. There is a whole world of evictions happening that we know nothing about because tenants are receiving those notices and self-evicting because they think they have no other option than to leave the property. It's also impossible to link those tenants with any kinds of services. That's the point where you would want to get the tenant into some kind of diversion program, but there's no way to do that because you don't know what notices are being issued. As Judge Saragosa already said, tenants don't think that notice is real. It doesn't come from the court. It's literally filled out in pen by the landlord and taped to the tenant's door. They don't think it's real, and they certainly don't think it starts a legal process that they have to respond to. It's also an area that is ripe for abuse. We talk to tenants all the time who are peppered with eviction notices because the landlords know, bad landlords know, let me clarify, bad landlords know that if they serve enough notices on the tenant will eventually miss one of those notices, and the landlord will be able to get a default eviction. Also, because the notice is coming from the landlord, the natural response for the tenant is to go talk to the landlord. Well, that's a hotbed of misinformation because the landlord bad landlords, again, have every motivation to mislead that tenant about what action they should take. The notice is just too complicated. It's become way too long. It uses legal jargon that it's way above the reading level of most tenants. And it's also confusing because, as I said earlier, the notices are all different periods. Some are one part, some are two part. Tenants do not know what to do in response to these notices. The other issue is the requirement that the tenant initiate the court case to protect themselves. This assumes that the tenant will actually receive the notice, will be able to read the notice, will understand the notice, and will be able to actually go down to the court and take action and file an answer in response to it. That is a lot of assumption. It also is simply counterintuitive. It is the only legal process that I know of where it's actually the defendant in the case, the person who is being sued, is initiating the court case. The defendant is filing the court case against themselves. It makes zero sense. And if you talk to any attorney who practices in civil court and you say, yes, the defendant files the answer first, they would laugh at you because it just doesn't make sense. it requires the tenant to file to protect themselves, even though the landlord may have absolutely no intention of moving forward with an eviction. These eviction notices shouldn't be used as just a reminder that, oh, by the way, rent is due. That can just be a letter to the tenant. This actually starts an eviction process. So every time the tenant receives one, they are required to go down to court, take time off work, and pay a filing fee to protect themselves in that eviction case. Again, it is a hotbed for misinformation. It's a hotbed for abuse by landlords. And it is a procedure that, as far as we can tell, is unlike anything in the country. No other state has a procedure like this. So tenants who move here from other states, if they receive that eviction notice and it tells them to go down to the court and file to initiate a court case against themselves, they think the landlord is making that up. So anything that can be done to simplify this process and make it more user-friendly, to target tenants at the earliest time possible, to provide wraparound services to those tenants, and to avoid as many evictions as can possibly be avoided is a great thing. It's a benefit to the tenants, it's a benefit to the landlords, and it's a benefit to the community as a whole. So Legal Aid Center is fully committed to working with Judge Zaragoza and the court and the other stakeholders to try to make this a reality and reimagine what evictions are like in Nevada. So with that, I'll turn it back over to Jonathan, but I am happy to answer any questions.
And I think Jim hit the most troubling thing is the answer is filed first. That's something that just has to be changed when we are addressing Chapter 40. And then I also think the notices coming through the court is a good idea, not only for data collection, not only for confusion, but those people who are self-evicting or who do enter the court process and are eventually evicted, they cost the county less money the earlier the county touches them, because that person is going to need social services at some point, right? They're going to interact with that system, and the further upstream we can get with that, the more effective the county can be. And so I think those reasons, to me, it makes sense to, one, collect data, and two, have the person who is initiating a lawsuit file a lawsuit. And with that, we can answer any questions. Thank you.
Well, thank you so much, Mr. Norman and Mr. Berthold. Very impassioned and informative presentation. I think we needed to know that, these steps one by one. And so this really, I think, clarifies things for many of us. I'd like to start on Zoom. If anyone on the Zoom call has any questions, I see the hand of Senator Pickard. Please go ahead, sir.
Thank you. And I'm not one to usually miss an opportunity to ask a question. First, as I said before, I used to do a fair amount of landlord-tenant work before I focused strictly on family law. I mostly represented tenants resisting evictions. So I have some insight into what people have to go through to get done. I also think that there's a lot to be said about how we characterize things. I don't characterize this as the answer is the first document. Obviously, the notice itself is the first document. And when we instituted as a state the summary eviction process, we did so to unburden the courts. And I don't disagree that it would be helpful to know how many evictions are noticed, to do so in a way that looks more formal. And since Judge Zaragoza has volunteered the justice courts to take that on, more power to him. I don't have an objection. But I want to try to understand the premise from which we're working today. First, we all say that adequate housing is a human right. I agree. And that I don't think anyone would dispute that we fill this need through private parties providing housing in exchange for payment, given the utter failure of public housing projects across the United States. But I noted that you suggested that the court proceedings should be mandatory before an eviction takes place, and that people should be given resources or that resources should be given to them. So I'm wondering how we publicly fund their, or it becomes public funding for the opposition to the eviction or the answer to the eviction. And, you know, constitutionally, isn't it true that we don't take property from citizens without due process and just compensation? That's a rhetorical question. I'm just thinking as we go through the steps of summary eviction, someone has failed, and I'm talking about the vast majority, not the bad landlords, because I agree they exist. But we're suggesting that they should now have to file a formal proceeding in every case, which is going to add cost. I mean, in your presentation, you mentioned that it's sometimes a very lengthy process. So if we're going to be adding costs, how do we not avoid passing that on to the tenant? I mean, we've already got a crisis. We've got rents going through the roof because of what the market is doing, what demand is doing. And so how do we not further burden tenants with these costs that are going to be passed on to them?
Jonathan Norman, for the record, thank you for the question. I think, you know, one thing that strikes me, if we're talking about having we're not talking about having the landlord file the formal eviction, which was the second eviction on the one slide. We're still talking about having a summary eviction process, just where the landlord files first. Presumably, they would have to pay a filing fee, and they may pass those costs on to the tenants, but the protections that due process could provide for those tenants, I think, is worth the potential of that cost being passed on. And as far as the you know, the upstream where you're having the notice filed with the court, I think Judge Zaragoza said that they would be, like you said, they volunteered for that and said they would do that at no cost. And I think it's important to note, there are going to be a lot of cases where, you know, maintaining that housing isn't possible, right? So getting upstream and starting talking about rehousing so that a tenant and a family is not facing that eviction that's going to put them into some kind of temporary housing, if they're lucky, doubling up with family members, and then eventually after several moves, that could take a year getting into a stable housing. I think that, you know, just because that notice, it doesn't mean we would just be trying to maintain that housing, because if somebody doesn't have the income for, you know, what that housing costs, then we're looking at rehousing. And I still think it's worth getting social services involved at that point so that we can start down that path, because that's better than the train wreck of a 24-hour lockout and what that does to those families. Thank you. And I don't know if Jim has any additional comments there. And I hope that answered your question.
Well, you touched on it, yes. What I'm trying to get at is, as we address the practical realities of what you're proposing, and I don't have a problem with filing, particularly if it's at no cost, as Judge Zaragoza had suggested. If they do that filing in an official way, much like I do with any other complaint that I file, and I'll dispute the idea that we would laugh, you know, civil attorneys would laugh at the idea of the defendant, the answer being the initiation of the lawsuit. It's not, the notice is. But in the vast majority of cases that I did, where the tenant was resisting the eviction because they didn't pay, there was a reason they didn't pay. It was usually a habitability question. And so that's a defense. And so the process worked. We prevented the eviction. We got the issues resolved, and the person didn't lose their housing. But to your point, when a person can't afford the house they're in, and I want to kind of set aside the anomaly of the COVID thing, because then once the government put a moratorium on evictions, a lot of people stopped paying rent that could have, but didn't, because they knew they couldn't be evicted. And so, and we see that rippling through the courts at various levels. So we know that that's true, at least at a small number of people. But as we identify these people, so following your logic, I just want to kind of play this out. We file the notice, they then file an answer or don't, but they presumably appear for a hearing, and they have an opportunity to present their case. This happens all the time. That's what Hearing Master Brown does probably 80 to 90% of the time. And so he's hearing these cases, and they've got to have a legal defense. In the meantime, the landlord, who's usually representing himself still has costs he has to bear. So what I'm driving at is we've got the legal costs, but now you're talking about engaging them with social services, which I agree they probably need. But how do we pay for it? That's not in any budget, to my knowledge. I've not seen that. These are additional cases that the county's going to pick up. Granted, it may pick them up earlier than later, but do we have any confidence that they're prepared to take that on now? And if not, what do we need to do to put that in place so that we're not ultimately shoving the burden on the landlords, who will necessarily, it's not maybe they'll pass it on, they have to pass it on. If they don't make enough money to cover their expenses, they go out of business. And that's not why they're in business. So I'm trying to look at this from a practical standpoint. How do we actually meet the need, and who's paying for it?
Jonathan Norman, for the record. I think for those people fortunate enough to have an attorney, they're able to raise those defenses like habitability. And for a lot of our low income individuals and our seniors with disabilities, the point where they can access that legal assistance often comes too late, and their ability to raise a habitability defense, I think, is not very realistic. So without access to an attorney. So whether the county is prepared, and we're talking specifically about Clark County in this scenario with the diversion court that Judge Zaragoza was discussing. One thing that will be important is if they roll out a CARES team, we can't overwhelm that CARES team because we have this resource. We may be able to do a good job with a certain number of cases, but if we overburden them, then they'll ultimately fail to provide, good services to the entire group. But I would say that having the ability for people to access services and attorneys, whether it's the Legal Aid Center, and have due process where they are having a complaint served on them, I think is just fundamentally important. And I do think that housing is extremely complicated, and where does the money come from is a concern. And where does our community go when we have teachers who can't afford to live in the community? So we're going to have hard choices kind of at every level.
Sure, and I don't disagree with anything you just said. My concern as a legislator is, essentially, how do we put it in place? How do we fund it? And Judge Zaragoza just said that there are 30,000 cases that they're dealing with, and that's 10% of the total. So we're talking about 300,000 cases, all of whom are going to be assigned a CARES team member or some social service provider. I don't know how that's even possible, not without a huge statutory change and an even larger fiscal note. I think this is a great dream. I just want to see how do we actually implement it, and I'm only seeing the superficial presentation kind of stuff.
Thank you, Senator Pickard.
Thank you. I guess the last comment I would make, if I may, Chair Summers Armstrong, I think, the diversion court, I think, is one pilot program, obviously, that's being developed in Clark County. I think the changes to 40 are a separate thing that has its own benefit for Nevadans. I do not think that, and I agree. You know, most attorneys who practice landlord-tenant, if they're not in our state, would, if you're like, I moved here from New Mexico about 5 years ago, and when I found out that and I understand you're saying that the court proceeding starts with a non-court document, non-filed document. When I heard that the answer is the first pleading that's filed, I was being told by an attorney who practices in this area, and I was like, I don't believe you. You know, I had to go look at the statute. So I think we can create a better statute that provides more due process and the possibility of better outcomes if we can then start piloting programs like diversion court. They're not going to solve the problem overnight, but they could create a template that we can move forward with and start building some momentum to provide more access to justice in the state and access to housing. Thank you.
Sure, and thank you, Madam Chair. I appreciate your indulgence. I just think that we don't want to get the cart too far out in front of the horse. We need to look at this from a realistic standpoint, because if we don't, then we're going to be pushing the burden on the landlords, and that's going to further raise the costs. And that's what I'm trying to avoid. So thank you.
Thank you, Senator Pickard. I think one of the items that is very clear here is that without data, we are all guessing, and we have to find some process by which we collect accurate data. And it may not be in the form that makes all of us comfortable, but at some point we have to have it in order to make the best and most informed decisions. And so I'm just hoping that...
Like, Judge Zaragoza has given us the means to do that.
And we're grateful. We just have to figure out how to implement it. And Judge, do you have any additional comments to make regarding that?
Thank you, Assemblywoman Summers Armstrong. I do. I would say Clark County Social Services is one of our very solid partners in this, and they would not be in support of this program if they didn't think that the funding was going to work out. In my conversations with Deputy County Manager Kevin Schiller, he informs me that it costs the county 5 times more money to rehouse someone who's been evicted than it does to address it on the front end. So I think there's a cost savings benefit that would have to be analyzed in this as well. And I think it's fair criticism that it's superficial presentation today. We are still in the development stages. We're still meeting. We've had one planning meeting. We're looking at grant funding for some of the positions that we're requesting. And we are still in those planning stages. One last final comment I'd make is that we've worked closely again with some of our stakeholders that are representing the Nevada Realtors and the Nevada Apartment Association, and they are developing their own types of notice and push of their tenants into resources before they ever even file an eviction notice. So they've come up with their own separate form that they're planning to push out to all of their landlords that would give them that push even before the eviction notice comes along. So we are working as a team to try to come up with the best solution, and I just offer that we're still working on it.
Thank you so much, Judge Zaragoza. I appreciate your comments and your follow-up. Do we have any other questions on Zoom? If not, Chair Scheibel, can you check to see if there are any questions in the Northern Nevada Chamber?
There are not. Thank you.
Very well. Here in Southern Nevada, are there any questions from those here in attendance? Well, I see none. I think mine have been answered, so I won't belabor this. Thank you so much, Judge Zaragoza. Thank you so much, Jonathan Norman and Jim Berchold. We appreciate you very much for all of this. Please stay engaged. We will try to stay engaged with you as well so that we can move forward to a very viable solution. At this point, we'd like to invite Ray Lathrop, the strategy team leader for Nevadans for the Common Good, and Barbara Paulson, also a strategy team leader for Nevada's for the Common Good. Thank you, ladies. Please proceed.
Thank you. Good afternoon. Thank you, Chair and committee members, for the invitation to be here today. My name is Ray Lathrop, and I am a strategy team leader with Nevadans for the Common Good.
And I'm happy to be here. My name is Barbara Paulson. I'm also a strategy team leader with Nevadans for the Common Good. Efforts to establish a broad-based community organization in Southern Nevada began in the midst of the 2008-2009 recession and was born of the desire of regular people in this state to participate fully in their future, fully in the decisions impacting their lives and the lives of the people that they care about. This work led to the founding of Nevadans for the Common Good in 2012. Our name states our purpose, Nevadans for the Common Good. We have 40-plus member institutions representing over 100,000 people across the state, a mixed membership of large, long-standing service providers, as well as smaller neighborhood-based support systems and congregations. Over the life for the Common Good has held neighborhood walks, workshops, small group meetings, and 3 large community actions, all to learn and to listen to our community. We talk to teachers, doctors, clergy persons, landlords, students, and service workers. We've probably talked to over 1,000 people. We heard a lot about uncertainty, and the anxiety surrounding the immediate future was really tangible in many of these conversations. Stories that we heard parallel what you've heard earlier in the day, and some that were shared just ahead of us through legal aid. People told us of their daily fear of losing their home, the trauma of living through an eviction, and the feeling that they were living on the edge, as one lady said. We've learned a lot, and we have better appreciation for how this current housing crisis, both in terms of the quantity of housing and the eviction process, is impacting many of our friends and neighbors. It is our hope that our public institutions are one way to provide protections and a safety net to people when they are needed. Nevadans for the Common Good advocates for and supports services through the justice system and public assistance programs, such as some sort of diversion court, as we've heard about today. However, the overall system needs to be just, and it needs to be easily accessible in order for it to be effectively utilized.
Right now, our justice system is not doing what we need it to do, and we've kind of heard that from every presentation today. There are many barriers and challenges to accessing justice. Specifically, the current summary eviction process is really not working for our community. This, by placing the burden of initiating court proceedings completely on the tenant without any information on how to do it. So for example, last year, Nevadans for the Common Good worked very hard to help families navigate the rental assistance program and, unfortunately, the eviction process. One family we connected with was waiting for the rental assistance application to be approved and had no ability to pay rent in the meantime. The pandemic had hit them hard, but they were proactive in reaching out for help. They spent every day in fear of when an eviction notice would come to their front door. And one day, they called us saying they had gotten a notice but didn't understand it. It said pay or quit, but it did not have the word eviction on it. That would be considered the first notice in the process we just learned about. We encouraged them to go to the appropriate courthouse immediately and file a response. So they went to the North Las Vegas courthouse, which doesn't have a self-help center, and continued to call us for every step of the way for support. 2 working adults juggling their obligations, barely able to keep up with the process within a 7-day time frame. Even though they knew that an eviction notice was going to come, they did not recognize it when it did and didn't know what to do after it arrived. This process leaves tenants scrambling to find new housing in an unreasonable short amount of time. Many individuals go into emergency shelters or weekly rentals as an immediate and transitional solution, only to be trapped there and unable to find any permanent solution in the future. This process places tenants at risk of losing their job, As they figure out what their next step may be, they go into crisis mode. This process leads to transiency for many families, affecting the access of health and social services, negatively affecting student outcomes, and increasing the risk to homelessness. This process minimizes the true level of problem since many people self-evict, so there's no accurate data on the real magnitude of evictions, as we've already heard today. Some evictions aren't being counted in the data unless tenants respond to that notice. And thus we can assume that as extreme as our eviction data is, the reality is much worse. So what does the data say right now? We've heard about some of these numbers, but data from the Gwynn Center between 2000 and 2016 indicates that Nevada's eviction rates are higher than the national average, second highest after Arizona in the Intermountain West. Some census tracts in Clark County alone are over two of them are over 5%. And the listed rates are undoubtedly low since so many evictions are not even counted.
Ray mentioned that one of the concerns is the potential loss of employment. A common view is that losing your job leads to losing your home. But evidence suggests that in many cases, people lose their home first. And then because of the instability created by no longer having a home, often the time they've had to spend during 7 days missing work or whatever, trying to cope with the situation, they end up without a job. So it's just the opposite of what we often think about. We also know from one study that the likelihood of job loss is estimated to be 11 to 22% higher for individuals who have been forced out of their homes, such as with eviction, compared to those who have not. And one study indicated that renters who are evicted tend to move to poorer, higher crime neighborhoods compared to individuals who move for other reasons. Time is limited to find a new home. If you're struggling to stay in the home that you're in, how much time do you have to devote to finding a new place to move to, particularly in the current housing market that we see in Clark County? And with an eviction on record, housing options become more and more limited. But the cost doesn't necessarily go down. Many people end up living in a weekly rental, an option with limited space or stability, but very high costs for what it actually provides. People who end up in that situation are caught in a cycle. They are using all their resources just to stay there week by week. They cannot save to get out of that situation and into any type of long-term rental. They're caught in the cycle. An eviction can initiate this cycle of housing insecurity and transiency. We heard one story from a woman who, with her husband, was fostering 6 children. They qualified for Section 8 housing, but the long waiting list limited this option for them. They were then evicted from their home during the pandemic because the husband was temporarily unemployed. They are now coping with 8 people living in a 1-bedroom budget suite while they struggle to regain financial stability. And I worry that they're never going to get out of that weekly because of the situation they are in. This transiency and living in limbo can impact access to needed services, create transportation issues, and lead to generational impacts when children's education and learning outcomes are affected. The negative impacts of being forced from one's home can become long-term. The cost to our community also goes up because the need for public services increases in both scale and for a much longer period of time when you have people constantly living in very temporary housing. And to just briefly mention a little bit about the impact on education, studies across the country on student outcomes in a variety of metropolitan areas show that student learning outcomes such as lower math and English proficiency, loss of math and reading growth, lower assessment scores, plus new behavior problems and increased risk of dropping out of school are closely tied to attendance, which is negatively linked to housing transiency. The more transient the family is, the greater the absentee is in school and negative outcomes. A review of Nevada data by the Gwynn Center supports those findings. Their analysis suggests a positive association between transiency rates, eviction rates, and school or low school ratings in Clark County. Specifically, schools with a higher than average transiency rate are located in neighborhoods where the average eviction rate significantly exceeds the state and county averages. Eviction is a problem in Nevada, affecting the well-being of all our residents. We are, in effect, creating a permanent underclass with little chance to escape an ongoing cycle of economic insecurity. The current system just does not work and must change.
Everyone deserves to be heard. Tenants should not be made to initiate court proceedings. They should be guaranteed. And a judge should hear evictions so that tenants has his or her opportunity to be heard and possibly connected with resources when they're there. We need to increase the time for tenants to transition and find new housing to lessen the stress and adverse effects of moving. As in all of the stories that we've heard, the short notice of summary eviction forces families to make drastic decisions about their housing security. The long-term consequences of the transitional step between one long-term rental and another traps our community in an impossible cycle. We need a fair process for both tenants and landlords. Ideally, no one should be in eviction court. Evictions are destabilizing, and we need a social safety net that supports our community from its first sign of challenge. The reality is that today, not enough of our tenants even have access to this process, have the means to engage with this process, or have the knowledge to navigate this process. As Nevadans, we stand together across a diversity of communities in recognition that much work lies ahead. We have built and continue to build a broad constituency across the state that understands the inequities that COVID-19 has further brought to light, as well as the long road required to strengthen our economy for the long term. Building a more just eviction process through the court is an essential part of this work, and we are committed to the work ahead and want to work with state leadership for a more just economy for all. Thank you.
Thank you.
Thank you so very much. We appreciate you staying all day. The information that you have shared with us is critical, and we're grateful. I'd like to go now to those on Zoom. If you have any questions for our representatives from Nevada for the common good. Very good. Chairwoman Scheibel, would you please let me know if there are any questions or comments, questions really, from the folks up north?
There are not. Thank you.
Thank you very much. Any questions or comments from those on the panel here in Southern Nevada? Thank you very much. We really appreciate you being here. At this time, I think that wraps us up for this portion of the agenda. I'd like to turn this hearing back over to Chairwoman Scheibel. Thank you so much for allowing me to step in here, and gavel is now yours. Thank you.
Well, thank you, Assemblymember Summers Armstrong. You did an excellent job, and it was nice to be relieved for a little while there, and thank you for walking us through those important and interesting presentations. That brings us to almost the end of our agenda. As you guys know, if you stay until the end, you get a special prize, which is the inside scoop on the request for proposals that's going to be posted on the Judiciary Committee website probably on Monday. It just kind of explains an outline for how to submit a proposal for a bill draft request if you'd like one to be considered at the August meeting. Accept them from anyone and everyone. There's not a form to fill out. You just have to put your request into a Word document or an email and send it to the committee. Doesn't guarantee that we'll hear it, but it does guarantee that we will review it, and then we can reach out to you and from there figure out what to hear at our August meeting during our work session. So I encourage you all to take a look at that, send in your requests, and that brings us to the last item on our agenda before we adjourn, which is the second public comment period. We will start with public comment here in Carson City. Anybody wishing to give public comment will have 3 minutes each. I already see we have some people coming down to the front. And whoever wants to go first, just go ahead whenever you're ready.
Thank you, Chair Scheibel. This is Nick Shepak with the Fines and Fees Justice Center. I'll be very brief. I just have to make a quick correction to something I had said on the record. I was asked earlier if the court system in Colorado was unified, and while it's a small discrepancy, it is actually integrated. Unified suggests, like in California and in Kentucky, that it is the Supreme Court down. In Colorado, the state courts have an administrative body, and then what would be justice courts are called county courts there, and their municipal courts have their own administrative body. They are unified underneath that particular body. The question was about data collection. So yes, they use the same systems. All that data is reported. It doesn't really change that, but it is not a true unified system. It is an integrated system. I just wanted to correct that.
Spoken like a true lawyer.
Good afternoon. My name is Jennifer Richards. I hold the office of the Attorney for the Rights of Older Persons and Persons with a Physical Disability, Intellectual Disability, or Related Condition. We shorten that to Rights Attorney. I'm appointed and serve at the pleasure of the Governor. I'm housed within the Department of Health and Human Services. Our motto is helping people. It's what we're here to do. I wanted to come today to give a voice to the over 450,000 older adults in our state and the thousands of persons with disabilities living in our state that are disproportionately impacted by evictions and homelessness. I'm happy to provide I'm happy to provide the committee some additional data points following today's presentations. In Nevada, we do have an elders count. The latest elders count was in 2021. That provides authoritative data on Nevada's older adults. It's a collaborative effort between the Center for Healthy Aging, the Office of Statewide Initiatives at the University of Nevada, Reno, and the Aging Disability Services Division. That report identifies that the number of older adults on the verge of homelessness and entering homelessness has increased. So we can see from 2018 to 2021, we had higher numbers on the verge of homelessness. Now they're homeless, right? And that reflects national data that I can also help provide the committee from the Justice and Aging and the National Low Income Housing Coalition. I did want to touch on 2 points from some of the topics today. One discussion was social services, and at our division, we have a slogan called "No Wrong Door," and that means whatever door you enter, it's not wrong, you're going to get connected to services. And I think Judge Zaragoza's presentation really emphasized that the courthouse needs to be a door that is not a wrong door to enter to get those services. But sometimes that's not just initiating services. Because of the eviction process in our state with the tenant as the first filer, they may already be involved with social services, and social services doesn't know. I know at our agency, we've had social workers in our community-based care team or in adult protective services have clients evicted because they don't know, they're not able to provide those social services supports to help keep them housed. It could be a non-payment issue. It could be an abuse, neglect, exploitation issue. It could be needing supports in the home so that they can maintain the habitability of the home and stay housed, whether that's a personal care assistant, getting on a waiver service, or any of our other services that we also subgrant to community partners. I also wanted to let the committee know that I serve as the state legal assistance developer for Nevada and oversee our legal services grants under the Older Americans Act. We have deployed additional funding, including the additional federal dollars, to support our legal services providers who are completely overwhelmed in responding to evictions. We're piloting a $500,000 neighborhood legal access program to meet people where they are in the community and partner with our public libraries. At our division, we had a total of 77,000 contacts from July 1 to March 30th, 2022, through our Nevada 211 asking for housing and shelter assistance. So if you look at the numbers, that's a huge amount contacting the Aging and Disability Network to receive assistance. So I think part of the problem is helping people to plug into the existing framework. And the process right now is difficult for persons with disabilities or older adults because it's not necessarily accessible. What if someone's blind? How are they going to read the notice posted on their door? At least if they go to the courthouse, there's ADA accessibility and someone can help walk them through what's going on. So I know it's 5 o'clock and I'll conclude there, but please feel free to reach out to me if I can be a resource to this committee.
Thank you so much. And we would definitely like to hear some more about the aging and disabled communities. So I think we will touch base with you before our next meeting. I don't see anybody else in Carson City, wherever I am, to give public comment. Is there anybody in person in Las Vegas?
There is not, Chair.
All right, then we will go to the phones. As I mentioned last time, I learned that we're on a little bit of a delay with some of the streaming options, so I am going to sit here for about 2 to 5 minutes to make sure that we don't have anybody on the phone line if there's not anybody there already. BPS?
Thank you, Chair. If you wish to provide public comment, please press *9 now to take your place in the queue.
Good afternoon, Chair Scheibel and members of the committee. This is Kendra Birchie, BERTSCHY, with the Washoe County Public Defender's Office. I want to thank the committee for again touching the issues of bail, which is extremely important. We want to thank this committee for their hard work that they've done so far during this interim, but also during the legislative session to enact bail reform. We did notice at the very end of the session during the conference committee that there was an issue involved in both AB 424 and SB 369 regarding how a person could appear back before the court and what remedies could be imposed for the different types of pretrial violations. So we are hopeful that this committee will consider looking at that and fixing the issue that was noticed, unfortunately too late to be implemented into any of the laws that were passed. Additionally, in respect to some of the fines and fees that were discussed, we are hoping that this committee will take a look at NRS 211A.130. What that statute does is it requires that a governing body implement a form of schedule of fees for probationers or those on supervised release. It requires a mandatory $20 fee which could be a higher fee depending on the policy that the governing body adopts. But the courts have no mechanism and no system to waive that fees for those who may be pending trial, who are there on supervised for release pending a trial, so are innocent until proven guilty, and those who have no ability to pay or are unable to pay a $20 monthly fee. As we learned during COVID, unfortunately, sometimes there are trials that can be continued for months or years due to reasons beyond the defendant's control. And so we're hopeful that this committee will take a look at that law in order to allow for some form of judicial discretion. We have noticed some issues with the delay in implementation between AB 424 and SB 369. As we all know, AB 424 will go into effect on July 1st. So I'm hopeful that some of those issues will be remedied at that point, but I will be reaching out to the committee and will include it in proposal for noticing that some of the struggles that the different courts have seen and just with how someone could be placed on an administrative order for release without the delay that we currently are seeing. We will bring that to the committee's attention. Thank you for your time, and thank you for paying attention for so long on these incredibly important issues. Thank you.
Hi, Jim Hoffman, Nevada Attorneys for Criminal Justice. I have three things I want to say very quickly. First, I want to thank Director Gonzalez from the Sentencing Commission. She has a thankless task trying to balance between different stakeholders, and I think she's doing an admirable job. Second, I want to say that NACJ strongly supports the idea of reviewing our framework for misdemeanors, and we co-sign everything that Ms. Mosley, Mr. Shepak, and the others said in that vein. Finally, I wanted to highlight the connection between housing policy and the criminal justice system. I know this committee has heard a lot of presentations during the interim, and a consistent theme has been that the lack of housing access is undermining various different pieces of our criminal justice system. I think the presentations today on summary evictions were really enlightening because they explained part of why that's happening. The summary eviction process is a confusing, technical system that ordinary people have trouble navigating. How much worse is that for someone who's in rehab and trying to maintain their sobriety? Or for someone who's out on probation and trying to keep a stable living situation instead of falling back into bad old habits? How are social service providers dealing with homelessness or mental health supposed to help people address their problems if those people are getting evicted left and right? Lack of stable housing is a very important cause of other social problems and eventually recidivism. So these reforms that Judge Zaragoza and the other presenters talked about, they aren't just important on their own merits. They're an important and necessary support for the criminal justice system as a whole. So NACJ supports those reforms as well. Thank you.
Hello, Chair and members of the committee. My name is Paul Catha, and I represent the Culinary Union. The COVID-19 pandemic has hit Culinary Union members and their families incredibly hard. While hospitality workers are slowly returning to work, tens of thousands are still unemployed and struggling with housing insecurity. Since March of 2020, the Culinary Union has worked with our housing fund and other organizations to keep workers in their homes. Unfortunately, there are still too many Nevadans who have lost their homes during the pandemic. Nevada must eliminate summary evictions because tenants should have the right to due process when threatened with losing their home. Every Nevadan deserves an affordable and stable home, and an eviction should never be a surprise. Working families and people of color are disproportionately impacted by housing insecurity, and the Culinary Union believes that every Nevadan deserves to be treated with dignity and that housing is a human right. Nevadans should not have to decide between having food on the table or a roof over their head. Thank you.
Chair, your line is open and working. However, there are no additional callers for public comment at this time.
All right. Thank you so much for your help. Thank you to everybody who joined us today. Again, I know it was a long meeting, but I think it was worthwhile. These, as a number of commenters and presenters said, these are really important topics, and they deserve our time and attention. So with that, our next meeting will be on Friday, June 10th. That one will start at 9 a.m. like normal, and I will see many of you there. We are now adjourned.